appeal in the matter of Ras Al Khaimah Investment Authority and Azima and others.
May it please you, my lord.
Yes. With opposed to, I have to say, for about the 10th time in the last 5 years, although I was told I could use the same login details as the case I did last week, he's telling me I can't. So opposed to needs to provide me at least with some more login details. And I'm proposing to close the computer because I find it distracting.
Understood, my lord. We will get those details for you.
For some reason, maybe it's just me, Mr Macefield, probably my wife would say it's your complete technical inability. But it seems
my
to
wife
happen
would
all
say
the
the
time.
same.
They say, oh, you can use these ones, and then it turns out you can't.
Well, I've got hard copy as well. I don't know whether your lordship has.
Well, I think the idea is that we
can bring things
all
up.
got hard copy files, so we can.
Understood, my lord.
And the other thing I want to say before you start is that in terms of timetable, for various reasons, we would like to finish promptly at 4 o'clock tomorrow.
Understood.
There isn't a problem today, and my guess is that we should finish by lunchtime on Thursday anyway.
I think so.
So just to let you know, if you can find a convenient moment tomorrow.
Thank you.
Okay.
Will do, my lord. My lord, in terms of appearances, I appear together with Mr Morrison for Dechert, the third defendant and appellant. My learned friends Mr Pilbrow, KC, and Mr Hoare appear for Mr Gerrard, the second defendant and co-appellant. And my learned friends Mr White, KC, and Mr Silverstone appear for Mr Buchannan, the fourth defendant and appellant. And my learned friends Mr Pluman, KC, Mr Leith, and Mr Wilmot Smith appear for the claimant and respondent, Mr Azima. Now, in terms of timetabling, we've agreed, subject to the court's approval, to a roughly equal division of time between the appellants on the one hand and the respondent on the other, as set out in the proposed timetable. I'm going to open the appeal on behalf of the appellants, and my submissions will take up about 3/4 of today. Mr Pilbrow will follow this afternoon. Mr White will follow briefly tomorrow morning, making additional points on behalf of their clients. And Mr Pluman will then have most of tomorrow, most of the following morning to make his submissions on behalf of Mr Azima, subject to allowing us about 45 minutes or so at the end by way of a short reply. My lords, at the heart of the appeal lies the question of what the Court of Appeal meant when it said in its previous judgment that the judgment of Deputy Judge Lenin in RAKIA's favour must, and I quote, stay in place irrespective of the outcome of the hacking counterclaim. And as the judge put it when giving permission to appeal, if your lordships note, it's in the core bundle, tab 15, page 7, paragraphs 25 and 26, the judge said, standing back, it could arguably appear as though I've permitted Mr Azima to challenge the original judgment of the deputy judge when the Court of Appeal was absolutely clear that that judgment must stand, whatever happens in the hacking counterclaim, whatever new evidence emerges, and furthermore that the Supreme Court seems to have agreed with that approach in refusing permission to appeal. Given the whole argument in relation to abuse of process is focused on the Court of Appeal judgment, and the extent to which it could be said to have ruled out any further challenges to the judgment in RAKIA's favour, based on the same or similar evidence coming to light, it would be appropriate for the Court of Appeal itself to determine if that is truly what it did decide and whether my interpretation of its judgment was wrong. And we say that the Court of Appeal's ruling was clear. When you look at what was being argued before it by Mr Azima, and when you look at the Deputy Judge's judgment, which was on appeal, and what the Court of Appeal ordered, we say that the evidence that Mr Azima had committed multiple frauds on RAKIA was so compelling that the Court of Appeal was saying that RAKIA's judgment against Mr Azima must stand, whatever the outcome of the hacking counterclaim, and whatever evidence emerged to support the hacking counterclaim, and regardless of whether the first judgment had been procured by fraud. And that the only elements of the Deputy Judge's judgment that the Court of Appeal said could be set aside if Mr Azima succeeded on the hacking counterclaim was the award of interest and costs. Indeed, that was precisely Mr. Azima's objection when he sought permission to appeal to the Supreme Court. As I will show, my lord, Mr. Azima asserted that the Court of Appeal was wrong to preemptively rule out the possibility of any challenge to RAKIA's main judgment, apart from the award of interest and costs, before the evidence in support of the hacking counterclaim had been adduced, and before the hacking counterclaim and the extent of RAKIA's duplicity had been determined. Mr. Azima also said that the result of the Court of Appeal's ruling was that regardless of how serious RAKIA's wrongdoing and deceit might be shown to have been, the judge hearing the retrial could not strike out RAKIA's claims, nor could he exclude evidence, nor would RAKIA's wrongdoing impact on its claims apart from interest and costs, and Mr. Azima's defense of equitable set-off would be dismissed. Now, Mr. Azima is right that that is precisely what the Court of Appeal ordered. However, the Supreme Court nonetheless refused permission to appeal. And having failed to get permission to appeal from the Supreme Court, Mr. Azima now seeks to get around the Court of Appeal's ruling that the Lenin judgment must stand. And in doing so, he has performed a volte-face on not one, but two distinct issues. By his first volte-face, Mr. Azima now suggests that he can commence fresh proceedings to set aside the Lenin judgment for fraud, having previously argued strenuously against being forced to adopt that procedural mechanism last time he was in the Court of Appeal, and having instead been granted his desired procedural route of remission, albeit on a more limited basis than he would have liked. And by his second volte-face, Mr. Azima now argues, contrary to his submission when seeking permission from the Supreme Court, that the Court of Appeal had not ruled out the possibility of a challenge to RAKIA's judgment if evidence emerges in the hacking counterclaim to suggest the judgment had been procured by fraud. But we say that Mr. Azima was right the first time round about what the Court of Appeal had meant, and that he is wrong now. The Court of Appeal had meant to preclude him from challenging the judgment in RAKIA's favour, whatever the outcome of the hacking counterclaim. Indeed, that was a point that the Court of Appeal repeatedly and expressly emphasised in its judgment at paragraphs 63, 122, 128, 145, 146, and 148, which we will look at. It was also why the Court of Appeal spelled out in its order that if the counterclaim succeeded, the only parts of the judgment in RAKIA's favour that could be set aside were the awards of interest and costs. And furthermore, there were cogent reasons of public policy that the Court of Appeal reached that decision. The Court of Appeal noted that Mr. Azima should have disclosed the hacked materials in any event. Those documents showed, and this cannot credibly be disputed, that Mr. Azima had perpetrated a massive series of frauds on RAKIA, forging and backdating sham documents, paying and receiving bribes, and lying about that both to RAKIA and to the court. Indeed, as I shall show the court, when previously pressed by the Court of Appeal, Mr. Azima's counsel, Mr. Tim Lord KC, was forced to concede that he was not challenging the underlying findings of fraud against Mr. Azima. And if RAKIA's claim against Mr. Azima was set aside, the Court of Appeal was concerned that would therefore leave Mr. Azima with the fruits of his wrongdoing. And there was a strong public interest against that, and a strong public policy interest in favour of finality of litigation. And what the Court of Appeal therefore sought to do, in its carefully calibrated ruling, was to strike a balance between the parties. The court held that on the one hand, if Mr. Azima could establish that RAKIA had hacked his documents and that he had suffered loss and damage as a result, then he could claim compensation for that damage from RAKIA. But at the same time, in light of his own mala fides, the court held that Mr. Azima should not be allowed to overturn the judgments that had been awarded in RAKIA's favour, other than the awards of interest and costs, which were the mechanisms by which the court could express its disapproval of RAKIA's conduct if it were found responsible for the hacking. So we say Mr. Azima is wrong to say, as he now says, that the Court of Appeal, properly understood, has not already ruled against him on this issue. It has, and his attempt to appeal that Court of Appeal judgment further to the Supreme Court has failed. Mr. Azima's only other argument is that fresh evidence has emerged since the Court of Appeal hearing and its ruling, which he says puts an entirely different complexion on matters, and which goes materially further than any fraud or dishonesty on the part of RAKIA that the Court of Appeal contemplated. But the case that Mr. Azima is running now, as I shall show the court, is the same case that he ran last time he was before the Court of Appeal and when he sought permission to appeal to the Supreme Court. He said then, and says now, that RAKIA had procured the Lenin judgment by fraud. In particular, it was Mr. Azima's case last time he was before the Court of Appeal that there had been massive and pervasive dishonesty involving all of RAKIA's witnesses. It was his case that RAKIA had procured the hacking of Mr. Azima, that Mr. Page and Mr. Halibi and probably other RAKIA witnesses had conspired to give false evidence about how they came across the hacked material, and that Mr. Buchannan and Mr. Gerrard had between them created a false paper trail through an exchange of emails purporting to break the news about the discovery of the Azima material on the internet. And it was Mr. Azima's case that the ruler had also given false evidence. And Mr. Azima claimed last time he was before the Court of Appeal that the pervasive dishonesty of RAKIA's witnesses about their knowledge of the hacking had contaminated the whole trial and called into question RAKIA's credibility more generally. In particular, it was said that RAKIA's witness evidence that they had relied on Mr. Azima's fraudulent misrepresentations was now unsustainable, and with regard to the conspiracy claim, it was said that there was in fact evidence that Mr. Azima had introduced buyers to the hotel. But the Court of Appeal, as we shall see, rejected those arguments and ruled against Mr. Azima that they would not have had a material impact on the Lenin judgment for reasons that we will look at. In short, my lords, nothing has changed so far as the case is concerned. That was Mr. Azima's case last time he was before the Court of Appeal. It remains his case now. He is attempting to have another bite of the very same cherry. And so far as the evidence is concerned, all that has emerged is evidence that arguably supports and corroborates Mr. Azima's case on the hacking and the cover-up. But in our submission, so what? The Court of Appeal had ordered that RAKIA's claims must stand whatever the outcome of the hacking counterclaim. It must have contemplated that evidence might emerge which would support the hacking counterclaim. Not only that, the Court of Appeal expressly contemplated that the hacking counterclaim might prevail, and Mr. Azima would prove on the balance of probabilities that RAKIA had hacked his data and its witnesses had lied about their involvement in the hacking to the court. But the Court of Appeal could not have been more clear. It said that irrespective of the outcome of the hacking counterclaim, i.e. even if it succeeded, RAKIA's claims against Mr. Azima must stand. Now, I was not going to say a lot about the law on abuse of process. First, because Mr. Pilbrow is going to address you on that, and will doubtless do a much better job than me, but also because we say that the law is pretty clear. If the Court of Appeal says something must not happen, and there is an unsuccessful attempt to appeal that ruling, if the unsuccessful appellant then tries, via a different procedural mechanism, to achieve that which the Court of Appeal said should not happen, that is an abuse of process.
Well, clearly, if you're right in the hypothesis you've put forward so far, then that must follow, mustn't it? I mean, the critical question is whether you're right.
Correct.
What it was that the Court of Appeal was talking about, which is the point the judge made.
Absolutely. And we
so actually, in a sense, the appeal turns on that question of fact rather than...
It does. We say there are three questions that the appeal turns on. The first is exactly the one my lord identified. What did the Court of Appeal decide before? Second, is Mr Azima trying via a different procedural route to achieve that which the Court of Appeal has said must not happen? And third, has there been a material change in circumstance that arguably might justify that renewed attack? And in answer to those questions, we say that what the Court of Appeal decided before was that irrespective of the outcome of the hacking counterclaim, the judgment in RAKIA's favour must stand. We say Mr Azima is trying to do that which the Court of Appeal said must not happen, and we say there has not been a material change in circumstance to justify that course of action. And so far as that last point is concerned, what constitutes a material change in circumstance will depend necessarily on what the Court of Appeal previously ordered. If the Court of Appeal previously ordered, as we say it did, that the judgment in RAKIA's favour must stand irrespective of the outcome of the hacking counterclaim, then clearly a win in the hacking counterclaim would not constitute a material change in circumstance. Nor can it be a material change of circumstance if before the trial of a hacking counterclaim, evidence emerges which arguably corroborates Mr Azima's earlier allegations. And what I would like to do in the remainder of my submissions is to address the court first on the Lenin judgment and the findings of fraud against Azima and what was said about the hacking. Second, to look briefly to see how the argument proceeded before the Court of Appeal, which is relevant to understanding the Court of Appeal's judgment and order. Third, to look carefully at the Court of Appeal's judgment and order. Fourth, briefly to consider Mr Azima's arguments to the Supreme Court. And fifth, to consider Mr Azima's arguments now and why he cannot establish a material change in circumstance, bearing in mind the width of what the Court of Appeal has previously ordered. Before turning to run through those submissions, I would like to say something briefly about why all of this matters to the additional defendants and why we are concerned that the Lenin judgment should stand as the Court of Appeal had previously ordered.
We're going to ask you that question.
Well, let me answer it now. The Lenin judgment, as I shall show the court, found Mr Azima to be a serial fraudster, forging documents, paying and receiving bribes, conspiring with others to defraud RAKIA, and lying both to RAKIA and to the court about what he had done, even in the face of the hacked material. And that finding of fraud has a material impact on Mr Azima's claims against the additional defendants, which are the subject of his hacking counterclaim for a number of reasons. First, due to the existence of an iniquity exception, Mr Azima cannot assert any confidence or reasonable expectation of privacy in documents which establish his fraudulent misconduct, either under English or, we say, Missouri law. The fact that Mr Azima was a fraudster who was legitimately exposed for wrongdoing is therefore relevant to liability. Second, Mr Azima cannot claim damages for distress for being rightly exposed as a fraudster. Third, the fact that Mr Azima was rightly exposed as a fraudster is a factor that we say the court can and should take into account when deciding if Mr Azima should be awarded exemplary damages, which is what he is seeking from the additional defendants. It's a point in mitigation that goes to answer that submission. And fourth, the fact that Azima is not coming to equity with clean hands is a reason why he should not be allowed to seek an injunction or a disgorgement of any profits made by the additional defendants. Now, as things stand, by paragraph 146 of its judgment, which we will look at, the Court of Appeal has said that the Chancery judge who hears the remitted counterclaim will not be bound by findings of fact on the hacking claim, but that the Chancery judge will be bound by the findings of fact made by Deputy Judge Lenin on the substantive claims. And it follows that absent Mr Azima's new set-aside counterclaim, the additional defendants could have relied on those findings of fraud against Mr Azima and could have moved straight to arguments about the legal consequences of those findings for Mr Azima's hacking counterclaim in terms of both liability and quantum. But if permission is given to bring the set-aside counterclaim, then those allegations of fraud will need to be traversed in detail, both as part of the court's consideration of the materiality condition on the set-aside counterclaim itself, and as part of the consideration of the hacking counterclaim, because if the set-aside counterclaim succeeds, we will want to prove that Mr Azima was indeed a fraudster, and therefore that the claims for exemplary damages or for privacy in respect of those documents can no longer apply. And for both those reasons, the effect of the judge's decision to give permission for the set-aside counterclaim is that the allegations of fraud against Mr Azima are going to have to be considered in detail once again at the forthcoming trial. And that will add considerably to the evidential burden at the forthcoming trial. Indeed, there was a hearing last week before the judge to consider the impact on the forthcoming trial, and it's common ground that there's going to be additional work about 2 to 3 weeks, which is about the time frame of the original proceedings before Deputy Judge Lenin, to go back over that ground. And we say that the learned judge was therefore wrong to say, as he did, paragraph 103 of his judgment, when granting permission to Mr Azima to adduce his new counterclaim, that it would not really add to the evidential burden at trial. It will do by the degree I've just indicated to the court, and it will require the parties to go back over much the same ground that was traversed in the original 3-week action between RAKIA and Azima, and to demonstrate why, once more, Mr Azima was a fraudster. It will lead to extensive re-litigation of that question of his fraudulent misconduct, which we say is precisely what the Court of Appeal was anxious to avoid last time round. And that is why we are concerned to ensure, as the Court of Appeal has previously ordered, that the findings of the Deputy Judge against Mr Azima should stand. So I hope that addresses the question that your Lordship wanted to raise with me about why we are doing this, why we are here. My Lord, if we could start then by looking at the judgment of Deputy Judge Lenin, which we have behind tab 1 in the supplemental bundle. And while we get that out, I'll just explain that the reason for doing this is because one needs to understand what the learned judge at first instance had found in order to put in context the argument before the Court of Appeal and to understand why the Court of Appeal determined the appeal in the manner that it did. And in particular, I would like to show the court briefly the overwhelming evidence of Mr Azima's fraud set out in the Deputy Judge's judgment, which the Court of Appeal had previously considered carefully on the appeal and took into account when making the order that it did. And it was precisely because the evidence of fraud and dishonesty was so strong that the Court of Appeal felt able to say that even if RAKIA was responsible for the hacking and its witnesses had lied about the way in which it came by the documents proving Mr Azima's fraud, those lies were collateral to the substantive question of Mr Azima's fraud. And what's important to note when we look at Deputy Judge Lenin's judgment and the evidence of fraud against Mr Azima is the extent to which the evidence turned on the hacked documents, which Mr Azima should have disclosed anyway, and second, on the inadequate, inconsistent, and implausible explanations that Mr Azima and Mr Adams, who was Mr Azima's associate, put forward for their conduct. In short, none of the Deputy Judge's findings of fraud turned on the evidence of RAKIA's witnesses. It turned on Mr Azima's own documentary evidence and his testimony.
What about the evidence of reliance? That can't have turned on what Mr Azima or Mr Adams said.
Correct. That issue turned on the evidence given by Mr Buchannan, and it was therefore necessary to that limited extent to establish and prove reliance. But as I'll show my Lord, that evidence from Mr Buchannan was supported by contemporaneous documents, point 1, and the Court of Appeal in the course of arguments raised the point with Mr Lord that even if it could be showed that Mr Azima's, that RAKIA's witnesses had lied on one issue, it didn't follow, it was a classic non sequitur to assume that they must necessarily have lied about everything else.
I followed that,
Yes.
but the settlement agreement is 2016.
Correct.
The evidence arguably points to yours, well, to the claimant's side, having known about Mr Azima's conduct in 2015. Doesn't that suggest that the new evidence or the evidence of hacking should bear on reliance and the not merely the evidence of Mr Buchanan, but more generally?
That was a point that arose in the first trial because one of the Project Beach reports, called the Project Update, had been disclosed by RAKIA, and it suggested that RAKIA was already aware and had concerns about Mr Azima's conduct. And there was another document called The View from the Window, which RAKIA also disclosed, which showed that RAKIA had concerns that Mr Azima had been involved in fraudulent wrongdoing. And therefore there was a very live argument at the first trial before the deputy judge about whether in those circumstances it could truly be said that RAKIA had relied on the good faith representation. Now, the judge found in RAKIA's favour on that because he said even if a party harbours suspicions about misconduct and wrongdoing, nonetheless you can rely on a representation of this sort. And he referred to the Supreme Court's decision in Zurich Insurance on that point. And there was no appeal to the Court of Appeal from that part of the reasoning of the learned judge. So it's a point we will look at because it crops up again in the course of argument before the Court of Appeal. But in short, we say there's no materially different case now. The documents already in play and disclosed in the first trial, it showed that there were concerns within the RAKIA camp about whether Mr Azima was acting in good faith. That was precisely why they wanted the assurance that he had acted in good faith before handing over 2.6 million. And the judge said that they were entitled to rely on that assurance and found that Mr Buchanan had done so. Now, broadly speaking, there were three claims against Mr Azima in the original action. First, there was the heavy... Sorry, excuse me a minute. First, there was the heavy lift misrepresentation claim that Mr Azima had fraudulently misrepresented the amount that his company, Heavy Lift, had invested in a pilot training academy joint venture with RAK Airways. Second, there was the good faith misrepresentation claim that Mr Azima had fraudulently misrepresented that he had acted in good faith in his dealings with RAKIA when he had not. And third, there was a claim in conspiracy to injure that Mr Azima had conspired with others to steal 1.5 million from RAKIA and had then drawn up a sham referral agreement in order to attempt to justify the payment and had paid a kickback of $500,000 to Dr. Massad, who was RAKIA's then chief executive officer, to buy his complicity in that transaction. And can we start by looking briefly at the judge's findings in relation to the Heavy Lift misrepresentation claim? We can pick it up within the supplemental bundle behind tab 1 at page 16, paragraph 78 of the judgment, under the heading, the Heavy Lift investment misrepresentation claim. And the judge, we can see, said this, he's summarizing RAKIA's case, 78.1. In order to induce RAKIA to pay him compensation, Mr Azima repeatedly represented that Heavy Lift had spent a total of $2.685 million in making its contribution to the Training Academy joint venture, including expenditure of approximately $1.726 million in respect to the flight simulator. This was untrue. Heavy Lift's actual expenditure on the Training Academy joint venture was very much less, between $850,000 and $1.2 million. Mr Azima knew that the Heavy Lift investment representation was untrue, and the amount invested by Heavy Lift was substantially lower than the sum represented. RAKIA suffered loss as a result of entering into the settlement agreement. And at paragraph 79, the deputy judge then set out Mr Azima's response to the claim. In short, he denied he had acted fraudulently for a number of reasons. And at paragraph 80, if we turn over the page, the deputy judge said the RAKIA's claim gave rise to a number of issues, which he then set out. And at paragraph 81, the judge then turns to address the first issue he identifies, whether the quantification in 2008 of the Heavy Lift contribution to the joint venture was fair and honest. And at paragraph 21, the judge noted that in early 2008, Heavy Lift had sought to prepare a set of joint financial accounts with RAK Airways for submission to Heavy Lift's auditors, PwC, and had sent a proposed balance sheet to RAK Airways in early 2008. And at paragraph 82, the judge notes the balance sheet showed total assets contributed by Heavy Lift of $2.2 million, including an amount of $1.7 million in respect of the simulator, including its delivery, installation, and certification, and an entry of $450,000 in respect of training aids. And if we then pass down to paragraph 90 on page 19, below the heading backdated documents, we can see that the judge turned to consider 3 documents that Mr Azima then caused to be drawn up and backdated. We can see at paragraph 92, the judge notes that there was a request for documents from an employee at RAK Airways, Mr Hegde, and that prompted Mr Adams and Mr Azima to produce a number of backdated documents designed to provide support for the figures shown in the balance sheet in respect to the simulator and the training aids. The judge finds that these were sent by Mr Adams to Mr Azima by email on the 27th of February, one sees that at 92.1, asking for him to sign them and send colour scans back. And in short, there were 3 such documents if we turn over the page. The first is dealt with by the judge at paragraph 92.2, and it's a bill of sale from Mr Azima to Heavy Lift for the DC-8 training aids, purporting to show Mr Azima had sold training aids to Heavy Lift on 31st December 2007, when that was not, in fact, the case, as one sees from the last sentence. The second document is at 92.3. Mr Adams also drafted a letter from Mr Azima to Amir Anway, who was Heavy Lift's financial controller, which was backdated to the 31st of October, which stated, "I hereby confirm that additional consideration totaling $832,000 from me was part of the total consideration for the acquisition of the simulator." And at paragraph 93, the judge said he accepted Rakia's contention that the backdated letter was a misleading document. It was not sent on the date it had been purported to send, and Mr Azima had not provided any additional consideration for the purchase of the simulator. And at 95, the judge turned to the third document, namely a backdated invoice, which purported to show Mr Azima had sold the simulator to Heavy Lift on the 31st of October for the price of $1 million, and that Heavy Lift had advanced the amount of $167,000 to Mr Azima, leaving a balance of $832,500 to Mr Azima. As the judge noted, none of this information was true. The judge also found that, as well as drawing up and backdating fictitious documents, Mr Azima and Mr Adams obtained a valuation report from an old friend of Mr Azima's, Mr Jeremy Leggett, which purported to value the simulator at $1.475 million. And this was based on projected revenues for the simulator provided by Mr Adams, but was then passed off to the auditors as independent and reliable evidence of the simulator's worth. The judge addressed that on page 21 under the heading "The Valuation Report" at paragraphs 98 to 105, and we can drop down to paragraph 105 for the judge's conclusion. The judge says this: "In my judgment, the AMCL valuation was not independent or a reliable appraisal of the simulator's value. Jeremy Leggett was a friend, and AMCL unquestioningly adopted Mr Adams's projections regarding the projected revenues and costs of the simulator. Mr Azima and Mr Adams were extensively involved in reviewing and proposing changes to the drafts of the valuation." And the judge then considered further evidence relating to the $450,000 supposedly spent on training aids at paragraphs 106 to 114. In short, further documents, including third-party invoices, were drawn up and backdated by Mr Azima and Mr Adams. And at paragraph 109, the judge noted that in his oral evidence, Mr Azima admitted that contrary to the terms of the backdated invoices, neither he nor Heavy Lift had made a specific payment of $450,000 to acquire training aids from the third party, Blosser Consulting. And at paragraph 111, the judge noted that in his oral evidence, Mr Adams was forced to concede that insofar as Heavy Lift's audited accounts were based on the representation that training aids had been independently valued at $450,000, the accounts were based on a false premise. The judge then deals with the PwC audit, which I don't think we need to look at, before setting out his conclusion on the first issue at paragraph 120, which we have on page 24, I'm grateful. He says, I consider the way in which Mr. Adams and Mr. Azima accounted for Heavy Lift's contribution to the joint venture, including the cost of the simulator and the training aids in 2008, was not reasonable or honest. At paragraph 121 and following on page 25, the judge then turned to deal with the second issue, which was the content of the representations to RAKIA between 2013 and 2015. And as he put it at 121, RAKIA's case is that through communications sent to RAKIA between September 2013 and November 2015, Mr. Azima repeatedly represented that Heavy Lift had invested a total of $2.685 million into the Training Academy joint venture, which included expenditure of approximately $1.726 million in respect to the flight simulator, as described in the documents provided to RAKIA. And then if we pass on to paragraph 123, below the heading of the backdating of the joint venture agreement, the judge says, before considering the correspondence, it's necessary to refer to the production in 2013 by Mr. Adams and Mr. Azima of the backdated joint venture agreement, shortly before Heavy Lift launched its compensation claim. And at paragraph 124, the judge sets out the sequence of events. Essentially, I won't read through the paragraphs, but essentially, between May and August 2013, Mr. Adams sent various iterations of the joint venture agreement to Mr. Azima, culminating in a version that was sent to Mr. Azima's yacht in the south of France at a time when Dr. Massad, who by this time had left RAKIA and no longer had authority to sign documents on behalf of RAKIA, was staying with Mr. Azima, and this document was then signed by Mr. Azima on behalf of Heavy Lift and by Dr. Massad, purportedly on behalf of RAKIA and RAK Airways, and then it was sent back to Mr. Adams. And at paragraph 125, the judge notes that in cross-examination, Mr. Azima and Mr. Adams denied retrospectively drafting, amending, and backdating the joint venture agreement in 2013. Instead, they claimed Mr. Azima was always in possession of a copy of the agreement that was signed on the 12th of April 2007, and between May and August 2013, he had been asking Mr. Adams to send him a series of drafts of the agreement so he could make sure that that was consistent with the document he had. And at paragraph 126, the judge notes, according to Mr. Adams, the revisions he sent in 2013 had all occurred back in 2007. At paragraph 127, the judge rejects that evidence. He says, I conclude the explanations given by Mr. Azima and Mr. Adams of these communications makes no sense and were untruthful. If Mr. Azima had simply asked Mr. Adams to send him all previous drafts of the agreement in his possession, as Mr. Adams claimed, which is inherently unlikely, they would not have been sent over a period of nearly 2 months in an involving sequence. Moreover, if the drafts were really prepared in 2007, one would expect to see them and emails exchanging them in 2007 in Mr. Azima's disclosure. And at paragraph 128, he said, I agree with RAKIA's submission. The overwhelming inference from the documentary evidence is that Mr. Azima and Mr. Adams retrospectively drafted the JVA in the summer of 2013. Mr. Azima and Dr. Massad, who by then had no authority to enter into agreements on behalf of RAKIA, then signed that retrospectively drafted and backdated document on board Mr. Azima's yacht on 25th of August 2013, and thereafter misrepresented to RAKIA that this document was the original document that had been signed on 12th of April 2007. And then under the heading, the correspondence, paragraph 129 and following, the judge turns to the correspondence between 2013 and 2015 concerning Heavy Lift's claim for compensation. And I'm not proposing to work through that correspondence, but what it showed and what the judge found was that on multiple occasions it was represented by Mr. Azima or his colleagues to RAKIA that Heavy Lift had actually spent sums in the region of $2.6 million on the Training Academy joint venture for which it wanted compensation. And if we move on to page 31 on the heading conclusion, we can see the judge's conclusion on this issue. paragraphs 130 to 131, he said this: the central issue is whether the communication sent to RAKIA in the period 2013 to 2015 concerning Heavylift's claim for compensation are to be construed as representations as to the amounts actually expended by Heavylift, or whether they should be construed more loosely as referring to valuations of Heavylift's contribution to the joint venture. I've come to the conclusion that the communications did amount to a representation that Heavylift had actually spent a total of 2.685 million in making its contribution to the training academy, including expenditure of approximately 1.726 million in respect to the flight simulator. And at paragraph 132, he sets out his reasons for that conclusion. And at paragraph 134, the judge then turned to address an argument advanced by Mr Azima that any representations that were made by Heavylift and not by Mr Azima. And having set out the arguments at paragraph 136 on page 34, the judge rejected them. He said, in my judgment, Mr Azima's contention that the Heavylift investment representation was made by Heavylift and not by him personally is artificial and lacking in substance. And then on page 35, paragraphs 138 and following, the judge turned to consider whether the representations were false. And at paragraph 138, the judge notes that RAKIA's case is that contrary to Mr Azima's representations to RAKIA in 2015, that the simulator had cost Heavylift upwards of $1 million, Heavylift in fact acquired the simulator in 2006 for just $167,500, as evidenced by the signed sale agreement with MK Airlines dated 7th of August 2006. And Mr Azima contends it'd be necessary for RAKIA also to prove that the out-of-pocket costs actually incurred by Heavylift on the simulator and training aids were less than represented. At paragraph 140, the judge says, I disagree. The communications regarding the simulator were clearly referring to the cost of the simulator itself, rather than the cost of the simulator plus ancillary services or equipment. In any event, the costs in respect of equipment and services provided in connection with the installation of the flight simulator failed to support a claim that the costs of acquiring and installing the simulator were more than $1.7 million. And at paragraph 141, accordingly, even taking into account the cost of ancillary services and equipment, the total costs incurred in relation to the installation of the flight simulator were nowhere near the amount represented to RAKIA by Mr Azima. Furthermore, it is now common ground that Heavylift did not make a payment of $450,000 in respect to training aids. There is in fact no evidence that Heavylift incurred any expenditure on this. The judge then turned to consider the issue of whether Mr Azima was aware that the Heavylift representation was false. He dealt with that at paragraphs 143 to 145 over the page at 36. And he concludes that Mr Azima must have been aware that the Heavylift investment representation was false. And at paragraph 146 on page 36, he then turned to the question of RAKIA's reliance on the Heavylift investment representation. He summarized RAKIA's case on reliance in paragraph 147. He said RAKIA's case was that it had agreed to pay $2.6 million to Heavylift on the basis that RAKIA had an obligation to compensate Mr Azima and Heavylift for the amount of money they had spent in contributing to the joint venture. As a result of representations made by and on behalf of Mr Azima, Mr Buchannan believed Heavylift's financial statements to be true and that it had spent a total of approximately 2.6 million on its contribution to the JV. As a result, Mr Buchannan formed the view that RAKIA should enter into the settlement agreement and pay the settlement sum in that amount, i.e. the 2.6 million that had been represented. So a clear connection between the representation and the sums paid under the settlement agreement. And at paragraph 148, the judge set out Mr Azima's case on reliance. And in summary, it was Mr Azima's case that the decision to enter the settlement agreement was taken by the ruler, not by Mr Buchanan. Mr Buchanan's evidence established his function was to make a recommendation, and that actual power rested with the ruler. Mr Gerrard's evidence was to similar effect. Mr Buchanan confirmed he did not know the ruler's reasons for entering into the settlement agreement. There was no evidence that the ruler had regard to or relied on the alleged representations made by Mr Azima, and that RAKIA had entered into the settlement agreement for ulterior motives and in bad faith in order to use it to keep Mr Azima on side in his negotiations with Dr. Massad. And then at paragraph 149 and following under the heading conclusions, the judge set out his conclusions on reliance. At 149, he directed himself on the law. At paragraph 150, the judge said that the evidence established that Mr Buchanan relied on the representation in deciding that RAKIA should enter into the settlement agreement. He says the payment of 2.6 million was calculated by him as the amount of Heavy Lift's total investment in the JP as represented by Mr Azima. Mr Buchanan was unable independently to verify what, if anything, was properly owing to Mr Azima. And the fact that Mr Azima was willing to stand behind the figures on which he was basing the claim was also reassuring.
That's a quotation from Mr Buchanan, is it?
Correct, my lord. And at paragraph 151, the judge said that Mr Buchanan then recommended to the ruler that RAKIA should enter into the settlement agreement. He said it was a reasonable inference that in deciding to enter the settlement agreement, the ruler was acting on the basis of Mr Buchanan's recommendation. Para 152, the judge said that the fact that the ruler was not personally aware of the Heavy Lift investment representation did not negate the reliance placed on the representations by RAKIA via Mr Buchanan. The judge noted if a misrepresentation is made to an agent who relies on it to make a recommendation to the decision-making principal that does not pass on the representation itself, the principal will nevertheless be entitled to relief. And at paragraph 153, the judge said, for reasons set out below in relation to the hacking claim, he was not persuaded that RAKIA entered into the settlement agreement for ulterior motives, negating reliance on the Heavy Lift investment representation. And at paragraph 154, the judge said that in short, the evidence established RAKIA did rely on the Heavy Lift investment representation. And at 155 and 156, the judge then dealt with loss. And then under the heading conclusion on the Heavy Lift misrepresentation claim at 158, the judge says he was satisfied that the evidence relied on by RAKIA in support of its fraud claim was sufficiently cogent and that RAKIA did not take unfair advantage of a failure to maintain the JV records. At 159, he therefore concluded that Mr Azima was liable to RAKIA in the sum of 1.73 million by way of damages for fraudulent misrep. So that was the judge's summary of the issues, the evidence, and his conclusions in respect of the Heavy Lift investment misrep.
That case doesn't give, or so far as one can tell, from 148 in particular, it doesn't seem to have been part of Mr Azima's case. Well, you knew all sorts of things about me, so you can't have relied on any representation that was made. He was denying. He was denying that there'd been a misrepresentation at all, and seeking to justify
Correct.
what he'd done by saying, well, actually, either what I said was true or I wasn't making the representations you allege. But what he wasn't saying was, well, you had all these suspicions about me, from which it's apparent you can't have relied on anything I said.
That argument is made in the context of the good faith misrepresentation, which is what
Not
we're just
made in the
coming on
context
to.
of this.
It isn't, but we'll see also when we come to look at the evidence that Mr Azima is praying in aid, because he says some of the Project Beach reports in fact show that RAKIA had access to the underlying financial accounts back in 2015. What the report actually exhibits is the balance sheet. I'll show the court this. The balance sheet that Deputy Judge Lenin found to be false and misleading, i.e. the balance sheet that shows Heavy Lift investing 1.726 million in the simulator and 450,000 for the training aids. So the document that RAKIA had in 2015 was the fraudulent document. And it was only as a result of the trial in front of Deputy Judge Lenin that it was established that in fact that was a falsely accounted document that didn't reflect the true position, once everything had been put under the forensic microscope. But I'll come back to that point, my lord. It's an important one because one needs to see whether the case has moved on and whether...
That's obviously one of the things that's troubled me in this.
I understand that, but I'll take my lord to the Project Beach report, which has got the information, and show my lord that it is, the document in question is the one that was found to be false. It doesn't show...
The essence of what was being said in relation to the Heavy Lift representation was you didn't rely on it because the person who made the decision didn't actually receive the representation, to which the answer is the one given by reference to the...
That was that, but one gets the more general,
It's the Glencore case.
by the time one gets to the Court of Appeal, there's a more general submission that if they lied about the hacking, then they may have also lied about reliance, particularly Mr. Buchanan. So one gets to that point. And when you turn to look at the material that's come forward now, as I will show the court, there isn't a Project Beach report that says actually the true cost of the simulator was $167,000 and he didn't spend anything on training aids. That's simply not there. All the Project Beach report shows is, and it is attached to it, is the internal accounts, which show the false amount, which show, if anything, that RAKIA continued to assume that he really had spent these monies on the simulator. But I'll come back to that. The deputy judge then turned at paragraph 160 following on page 40 to address the good faith misrepresentation claim. We can take that a bit more shortly. The judge starts by summarising RAKIA's submissions at paragraph 160 as follows. By agreeing to clause 3.2 of the settlement agreement, Mr. Azima represented to RAKIA, in order to induce it to enter into the settlement agreement, that he had at all times acted in good faith and with the utmost professional integrity in his dealings with RAKIA and other RAK entities. In entering into the settlement agreement and paying the sum of $2.6 million to Heavy Lift, RAKIA expressly relied upon the good faith representation. In fact, by reason of Mr. Azima's wrongful conduct, the good faith representation was false. The good faith representation was made by Mr. Azima knowing that it was false, and as a result, Mr. Azima's fraudulent misrepresentation, RAKIA has suffered loss. And at paragraph 161, the judge then summarised Mr. Azima's defence to the good faith representation claim. The clause 3.2 did not constitute a representation, that the allegations of wrongdoing were denied, that Mr. Azima's conduct was not contrary to the good faith representation, that RAKIA did not rely on the good faith representation and so did not suffer any loss. And at paragraph 162, the judge says the good faith misrep claim therefore gave rise to the following issues. Did it constitute a representation? Were the allegations of wrongdoing established? Was the alleged wrongdoing contrary to the good faith representation? And did RAKIA rely on the good faith representation? And on the first issue, whether clause 3.2 of the settlement agreement constituted a representation, at paragraphs 163 to 165, the judge held that it did as a matter of construction of the agreement. On the second issue, Mr. Azima's wrongful misconduct, at paragraph 166, the judge listed out 6 aspects of Mr. Azima's conduct that RAKIA claimed were wrongful. The first 3 were first falsely claiming to have introduced buyers to the Sheraton Hotel transaction, the Sheraton Hotel in Tbilisi, Georgia. Second, fraudulently procuring RAKIA to pay the sum of $1.56 million in purported consideration for non-existent referral services and creating a sham referral agreement intended to conceal that misappropriation and the payment of a bribe of $500,000 to Dr. Massad in connection with the sale of the hotel. And third, entering into a dishonest secret commission arrangement which would have enabled Mr. Azima to obtain an interest in the hotel worth more than $6 million in exchange for a nominal payment of $10. Fourth and fifth allegations of misconduct need not detain us. And the sixth allegation of misconduct was the one we've seen the judge has already dealt with, whether Mr. Azima made fraudulent misrepresentations regarding the total costs that Heavy Lift had incurred through its contribution to the Training Academy joint venture. And the judge therefore turns to address the other 5, having already decided that 6th allegation in RAKIA's favour. And on the question of whether Mr. Azima falsely represented to RAKIA that he had introduced prospective purchasers of the hotel to RAKIA, the judge dealt with that at paragraph 168 and following. He started by citing Mr. Azima's account in his witness statement of how he came to introduce the Iranian buyers to the hotel transaction. And at paragraph 169, the judge noted that Mr. Azima exhibited photographs of meetings taken of a meeting in Istanbul, the metadata for which indicated that the 4 of them were taken on 26th of August 2011, one of them on 28th of August 2011. And at paragraph 170, the judge noted that Mr. Azima also relied on a number of contemporaneous documents which it was submitted supported his case that he had referred the potential buyers to RAKIA. And at paragraphs 171 to 173, the judge then set out the parties' competing submissions. And then under the heading conclusion, at paragraph 174 to 177, the judge set out his findings on the first allegation of wrongdoing. He said that discerning the role of Mr Azima in relation to the intended hotel transaction was not straightforward. There were no independent witnesses. The photographs and emails showed that Mr Azima certainly had meetings with the potential buyers and was actively involved in facilitating the possible purchase, but they fell short of establishing that Mr Azima was instrumental in actually introducing the buyers to the transaction. The fact that RAKIA's lawyers appeared to have been under the impression that there was an introduction was inconclusive, as they might have been misinformed. The judge felt that contrary to RAKIA's submission, the short interval between the date of the alleged introduction and the signing of the Memorandum of Understanding did not preclude the possibility that Mr Azima had effected the introduction. However, at 176, the judge found that the Adams Memorandum fatally undermined Mr Azima's case that he had introduced the potential buyers. The judge said that the Adams Memorandum was evidently intended to constitute a formal and accurate record of events. It was a short document. It was sent to Mr Azima on the 1st of March 2016, and Mr Azima never requested any corrections or changes to be made to it. And the fact that Mr Adams struck, and he referred to the fact that Mr Adams struck the judge as a careful draftsman who would not have described the circumstances of Mr Azima's involvement with the potential buyers without the instructions and approval of Mr Azima. Paragraph 177, the judge rejected Mr Azima's explanation for what was, on Mr Azima's case, a glaring error in the Adams Memorandum on the basis of time lag. The judge said that in his view, the memorandum was more reliable evidence than the self-serving evidence of Mr Azima and Mr Adams. He concluded that whilst Mr Azima was involved in the transaction and might well have had some expectation of a fee for his services, it did not affect the introduction of the potential purchasers. And at paragraph 178 and following, the judge then turned to the next allegation of wrongdoing, namely whether the referral agreement by which Mr Azima claimed to be entitled to the payment of 1.5 million that he received from RAKIA was a sham. The judge started at paragraph 178 by summarising Mr Azima's case. Mr Azima's case was that he initially agreed with Dr Massad to introduce buyers to the hotel transaction in return for a commission of 5% from the gross sale price plus 50% of any amount in excess of $50 million. After signing the Memorandum of Understanding, Mr Azima claimed that he received a call from the US Embassy in Georgia, during which he was advised that he should have nothing to do with the potential buyers who were a front for undesirable elements in Iran. As a result of the call, Mr Azima said he became concerned about the potential buyers' true intent in establishing a presence in Georgia and declined to participate further. A short while later, he informed Dr Massad and the ruler that he felt that the potential buyers had another agenda and mentioned his concern about possible contravention of US sanctions. Dr Massad told him after that conversation that the ruler and Dr Massad wanted him to step out of the purchase process and accept a 2.5% commission instead of the 5% originally agreed, and to forego his entitlement to the 50% of the excess above 50 million. And the sale then went through, and on the 25th of October 2011, Mr Azima received $400,000 from RAKIA, and in January 2012, he received a further 1.162 million, making a total of 1.562 million, which was, so he said, the 2.5% of the purchase price of 62.5 million. The learned judge then referred at paragraph 179 to further submissions on behalf of Mr Azima, before turning page 49, paragraph 180, to RAKIA's submissions. RAKIA's first point was that the terms of the original agreement for which Mr Azima contended were implausibly generous. 5% from the gross sale price and 50% of any amount in excess of 50 million would have meant Mr Azima was entitled to commission of $9.375 million on the sale of the hotel for $62.5 million. RAKIA was saying that that was a wildly generous fee for an introduction agent. The terms of that initial alleged agreement, RAKIA said, were not recorded in any written document or referenced in any contemporaneous email or set out in Mr Azima's pleaded case. On Mr Azima's case, he was told to forego that entitlement to more than $9.3 million and instead to accept a payment of just $1.56 million, despite having fully performed his side of the agreement. RAKIA submitted that was also inherently implausible and unsupported by the documentary evidence. RAKIA submitted Mr Azima's evidence concerning his alleged withdrawal from the sale was internally contradictory. The judge summarised those submissions at 180.4 to 180.7. The judge then noted RAKIA's submission that the process by which the referral agreement was drafted was also suspicious, which he sets out at paragraphs 180.8 to 180.10. In short, it was drawn up after the event, several months after the event, with travelling drafts passing between Mr Adams and Mr Azima once more. The judge also noted at 180.11 to 180.13 RAKIA's submission that the referral agreement referred to the wrong entities. One sees that at paragraph 180.11. It included extensive changes and additional terms, such as a term reimbursing Mr Adams for his expenses, which Mr Adams accepted had not previously been agreed, and a commission rate that on Mr Azima's own evidence had never been agreed. And the judge also noted at 108.14 to 180.17 that RAKIA's submission that the use of Mr Al-Sadek's private Gmail address during the drafting process was not adequately explained by Mr Azima and Mr Adams. Mr Al-Sadek was a RAKIA lawyer, and various drafts had been sent to his private Gmail address, with Mr Adams asking Mr Al-Sadek whether he should also send it to his official RAKIA address. And the judge found that there was, Mr Adams hadn't explained why he had asked Mr Al-Sadek if he should now send the document to his official RAK email address. And having set out those submissions at some length, at paragraph 181, the judge then sets out his own conclusions on the allegation that the referral agreement was a sham. In short, he agreed with RAKIA that the referral agreement did not reflect a genuine agreement with RAKIA, and that it was a sham intended to conceal the misappropriation of funds by Azima. And he said he reached that conclusion for a number of reasons. First, the judge accepted that the terms of the initial undocumented agreement for which Mr Azima contended were implausibly generous. Second, it was wholly implausible that Mr Azima subsequently agreed that his commission was to be cut by 50%, even though he had fully performed his side of the bargain. Third, he believed that Mr Azima had not effected any introduction to the potential buyers. Fourth, Mr Azima's case that the referral agreement simply enshrined an agreement that had been made in October 2011, the judge said was not sustainable. For example, Mr Azima had conceded in cross-examination there was no agreement in October 2011 that RAKIA would reimburse his expenses. Mr Adams had made a similar concession. And fifth, the judge said that the way in which the referral agreement was drafted was suspicious. The use of Mr Al-Sadek's private Gmail address and the request for permission to use the RAKIA email address indicated that Mr Azima and Mr Adams wished to conceal the referral agreement from RAKIA. The judge said he did not accept that there was any plausible explanation for the use of the private Gmail address. And sixth, the judge held that the omission on the part of RAKIA's counsel to challenge Mr Azima in relation to the alleged agreement of the ruler to the payment of the commission and to put certain elements of RAKIA's case to Mr Adams did not require him to reject RAKIA's case. And at paragraph 182, the judge then turned to a related allegation of misconduct, namely whether the payment of $500,000 made by Mr Azima to Dr Massad was a bribe. He noted at paragraph 182 that the bribery allegation formed part of RAKIA's case, that the referral agreement was a sham. And then he noted at paragraph 183 that it was common ground that on the 18th of January 2012, being the same day as the second payment of $1.1625 million in respect of the hotel transaction, Mr Azima made a payment of $500,000 to Dr Massad. The judge then noted the rival contentions. It was RAKIA's case that the payment was a bribe. It was Mr Azima's case that the payment was for the attempted acquisition of a 25% stake in an aircraft owned by Dr Massad. In paragraph 184, the judge summarized RAKIA's submissions, which we can pick up over the page at page 54, grateful. Paragraph 184, RAKIA noted that contrary to Mr. Azima's claims that Dr. Massad had a 50% interest in a Hawker 800A aircraft, 3 sets of contemporaneous documents, which the judge sets out in subparagraphs A to C, showed that the aircraft was wholly owned by the ruler. And Mr. Azima conceded in cross-examination that he did not recall seeing documentation that showed that the ruler was the owner, but claimed that he would have assumed that Dr. Massad's 50% interest was a beneficial interest. So on Mr. Azima's own case, he paid $500,000 for an interest in an aircraft without knowing the nature of the interest he was acquiring and without documentary proof of that interest. Mr. Azima reduced no evidence that the hull value of the aircraft was approximately $2 million. When asked in cross whether he had taken any steps to have the beneficial interest valued before paying the $500,000 to Dr. Massad, Mr. Azima claimed he had taken Dr. Massad's word at face value. RAKIA said that was implausible. RAKIA also noted there were no documents evidencing any planned or attempted transfer of an interest in the aircraft from Dr. Massad to Mr. Azima. RAKIA also noted that the aircraft was included as a company asset in the sale company agreement between Dana Air and Captain Burgundy. That sale agreement was apparently signed by Dr. Massad on behalf of Dana Air on 15th December 2011, which is about 1 month before Mr. Azima's payment. And it was unlikely that Dr. Massad would have entered into an agreement with Mr. Azima to sell the share in the aircraft, where he was aware that the aircraft was likely to be sold to a third party as part of a sale of Dana Jets. RAKIA also noted that 5 days after Mr. Azima paid the $500,000 to Dr. Massad, he sent an email to Dr. Massad discussing arrangements for a lease of the aircraft. The email didn't contain any reference to Mr. Azima owning a share of the aircraft, as would be expected if he had become a 25% owner less than a week earlier. 2 days later, Mr. Adams emailed Mr. Azima saying Dr. Massad would not commit because they were selling to Dana and the Hawker was to be part of the sale. As that, Mr. Azima could not explain why he was seeking to negotiate a lease on an aircraft in respect of which he was already a joint owner, and neither Mr. Azima nor Adams expressed any surprise or concern on learning that the aircraft in which Mr. Azima had just acquired a 25% stake was about to be sold to a third party. RAKIA also relied on the timing of the payment to Dr. Massad on the same day that the $1.1625 million was paid by RAKIA to Mr. Azima, which strongly suggested that the payment to Massad was linked to that payment to Mr. Azima rather than an entirely unrelated and undocumented aircraft transaction, and so on. And the judge then set out Mr. Azima's case in rebuttal at paragraph 185, which in the interests of time that I will pass over, and we can pick it up at paragraph 186 on page 58 under the heading Conclusion, where the judge says this: RAKIA's case that the payment of the $500,000 was a bribe paid to Dr. Massad rests essentially on the inference to be drawn from the fact that the payment was made on the date Mr. Azima received a fee authorized by Dr. Massad, to which he had no entitlement, and the absence of any convincing alternative explanation for the payment. At paragraph 187, the judge said that in his judgment, the explanation put forward by Mr. Azima that the payment was in exchange for a 25% interest in the Hawker 800A aircraft did not stand up to scrutiny in the absence of any documentary evidence showing that Dr. Massad had any interest in the aircraft or documentary evidence of the proposed purchase. And at 188 to 189, the judge said that although reasons for various subsequent payments made by Dr. Massad to Mr. Azima were unclear, the lack of a clear explanation for those subsequent payments did not displace the inference to be drawn that the unexplained payment made by Mr. Azima of $500,000 to Dr. Massad was a bribe. And at paragraph 119 following, the judge then turned to consider RAKIA's alternative case that if the referral agreement was not a sham but was genuine, then Mr. Azima had failed wrongfully to disclose to RAKIA his interest in the hotel transaction. And we can go straight away to the judge's conclusion on page 60, paragraphs 192 to 196, where the judge starts by noting that the question doesn't strictly arise, given his finding that the referral agreement was not a genuine agreement. But in short, the judge concludes that if it was a genuine agreement, Mr. Azima should have made full disclosure to RAKIA of the fact that he would acquire a 10% interest in the purchasing entity, the Eurasia Hotel Holdings Limited, worth about $6 million in return for a payment of just $10, together with unspecified good and valuable consideration. But Mr. Azima had failed to make that disclosure to RAKIA. Then the third and final cause of action that RAKIA relied upon was a claim in unlawful means conspiracy. We can deal with that very shortly. It's paragraphs 247 to 250 of the Lenin judgment on page 80. And as the court can see from paragraph 247, RAKIA contended Mr. Azima had conspired with others, including Dr. Massad, Mr. Adams, and Mr. Al-Sadek, to procure the illicit payment of 1.562 million from RAKIA and to conceal that by means of a sham referral agreement. We can see the judge's conclusion at 249. He says, in my view, it is to be inferred from the fact that Dr. Massad received a bribe out of the illicit payments and from the involvement of Mr. Al-Sadek in the retrospective drafting of the referral agreement that Mr. Azima had agreed, at least with Dr. Massad and probably with Mr. Al-Sadek, that the illicit payment would be made. So he found at para 250 that if Mr. Azima was liable to pay damages to RAKIA for the commission of the tort of unlawful means conspiracy. And then finally on the hacking counterclaim.
Just before you do, going back to the point you were making earlier, paragraph 244 is relevant, is it, to the reliance question? That's where there's reference to harbouring suspicions.
Yes, I'm grateful, my lord. My lord is quite right.
Reliance.
Reliance on the good faith representation, and that showed that there was an issue, a live issue, in the first trial about whether reliance was negated by the fact that RAKIA harboured suspicions about Mr. Azima's conduct. And one sees the argument at 243.4. The judge starts by looking at the settlement agreement, clause 3.2, which expressly records that the payments made in reliance, and then refers to the evidence of Mr. Buchannan at 243.4. He explains in his witness statement, prior to the execution of the settlement agreement, I was aware of allegations having been made against Mr. Azima and concerns expressed about his conduct. So Mr. Buchannan was being open about that. He said, however, had I known what I know now, and so far as concerns Mr. Azima's wrongdoings towards RAKIA, there is no way I would have agreed to recommend that he be paid 2.6 million. However, at the time, I was reassured by his willingness ultimately to agree the wording of clause 3.2 of the settlement agreement. And the judge says at 244, the evidence established both Mr. Buchanan and the ruler relied, whilst they may have harboured suspicions about Mr. Azima, it does not follow that they did not rely on the good faith representation. The fact that a representee harboured suspicions regarding the honesty of a representor does not negate inducement, and the reference to Zurich insurance that I mentioned earlier this morning. I'm grateful, my lord. The judge dealt with the hacking claim at the end of his judgment, which he dealt with very carefully and comprehensively at paragraphs 251 to 384. In the interests of time, we can pick it up with the judge's conclusion, which we have at page 124, paragraph 373 and following. Page 124, 373. And at paragraph 374, the judge said that Mr. Azima invited him to find that not only that Mr. Page had arranged for Mr. Azima's emails to be hacked, but also that RAKIA's main witnesses, Mr. Buchanan, Mr. Gerrard, the ruler, Mr. Page, Mr. Halabi, and Mr. Bustani had conspired to present a false case to the court and had given perjured evidence in support of that false case. So just pausing there, it was Mr. Azima's case at the first trial, and we'll see it's also his case in the Court of Appeal, that there had been a cover-up conspiracy involving all of RAKIA's witnesses. And at paragraph 377, the judge said that a number of facts and matters supported the inference that the hacking of Mr. Azima's emails was carried out by Mr. Page, acting on the instructions of the ruler, and he sets those out at some length. And at paragraph 378, the judge said that there were a number of significant features of Mr. Azima's hacking case which were improbable and pointed away from RAKIA having responsibility for the hacking. And he sets those out at 378. And then if we turn on to page 126 at paragraph 380, cutting to the chase, the judge said he accepted it was not impossible that Mr Azima's hypothesis was correct, namely that Mr Page, acting with the express or implied authority of the ruler, was responsible for the hacking. At paragraph 381, however, the judge said it was not enough for Mr Azima to advance a case that was not impossible, and said that he was not satisfied on the balance of probabilities that RAKIA was responsible for the hacking of the emails. And at paragraph 384, the judge said that if he had found that RAKIA had hacked Mr Azima's emails, he would not necessarily have excluded the illicitly obtained evidence, as without it, RAKIA would not have been able to prove its claims, and Mr Azima would have been left with the benefit of his seriously fraudulent conduct. But the judge then said if he had found that not only had RAKIA hacked Mr Azima's emails, but that its witnesses had conspired to put forward a fabricated case concerning RAKIA's lack of involvement in the hacking, there would have been strong grounds in the judge's view to strike the proceedings out as an abusive process. But we will see in a moment the Court of Appeal disagrees with that conclusion. So, my lords, that was the Lenin judgment, which was before the court the last time the case came before this court. And in our submission, it clearly demonstrated that Mr Azima had perpetrated numerous frauds on RAKIA. He had forged documents, he had paid bribes, he had taken a secret commission on the hotel transaction, and he had lied about those matters, both to RAKIA and to the court. And the judge's conclusions in that regard rested primarily on Mr Azima's own documentary evidence and on the inadequate, inconsistent, and implausible explanations that both he and Mr Adams put forward for their conduct. And we say that those findings of fraud, grounded as they were primarily on Mr Azima's own documentary evidence and testimony, helps to explain why the Court of Appeal went on to make the order that it did, that the findings of fraud against Mr Azima must stand, whatever the outcome of the hacking counterclaim. I'm conscious of the time. Is that a good moment to pause, because I'm about to move on to the Court of Appeal?
Well, we'll have a break for the transcribers, but can we keep it to 5 minutes, please?
Thank you.
I've got some login details for the judge. Is he in?
Brilliant. Yes, if we could pass those back.
Do you want to do it? Do you know how to do it? The magnet. Yeah. Oh, I can do it. There, yeah.
It gets clearer. I agree. Sorry.
Whether this reference forward that the hacking counterclaim shows that the judge took into account the suggestion that the already got
Yes. I think it might. mind if you
No, no,
pick
no,
that
no,
up
no,
when
no.
there's other points in your,
Absolutely.
just
No,
because
no.
I want to be, I don't want to,
No, you don't want to
they've
go back.
indulged me
Mm.
quite a lot, I don't want to spend more time on waiting.
Yeah. Anyway, it seems to me it matters most what is
Yeah, agreed.
They have? Okay. Thank you very much. They're not it? They've left the room? Can't be further. Now I need... I don't need that one, so feel free to speak. Right, hello, yeah, so we can also add 5 laptops, but I don't see
That's
the
optimistic, I
space.
think, yeah. But
Maybe
those
I
main
might-
guys over there.
Right,
You can have that one. I can't think anything.
sure, yeah,
They say they
okay.
need 5.
I don't think this is.
Right,
I don't think this
thank you very much.
Take this one away, yeah? I mean, you can leave it. It's easy for you, but I don't need it, so that should be. Whatever.
I mean, you can also have 5 extra laptops. Running this was like, doesn't seem to be the case. I can try to squeeze in 2 or 3 maybe. Sure. We'll just add some background, just 2. Cool, so try and put that one there.
They need more space. It's too small.
This one. We do, yes. She wants an extra 3.
My lords, Mr Azima then sought to appeal the Lenin judgment, and the court has Mr Azima's amended grounds of appeal behind tab 5 in the supplemental bundle. It's worth just looking at those because we'll see when we look at the argument and the judgment, there's quite extensive cross-reference to the grounds. It's worth just having them in mind. So tab 5, page 1 of the supplemental bundle. The main focus of grounds 1 to 4 is an attack on the judge's findings in relation to RAKIA's responsibility for the hacking. Ground 5, which is the ground that the Court of Appeal ends up taking first, if we go over the page, asserts that if the judge had found that RAKIA was responsible for the hacking, he ought to have struck out the claim for an abusive process or excluded the evidence obtained by hacking. In consequence, ground 6 says that the counterclaim was wrongly dismissed. Grounds 7 to 9, as originally formulated, made further criticisms of the judge's findings of fact in relation to RAKIA's claims against Mr Azima. Ground 7 challenged the judge's findings of reliance in relation to the heavy lift investment and good faith misrepresentation claims. Ground 8 challenged the judge's findings in relation to the unlawful conspiracy claim. And ground 9 challenged the judge's alternative finding that Mr Azima had failed to disclose to RAKIA the interest he had acquired in the Eurasia Hotel holdings and the extent to which he stood to profit from the hotel transaction. And as one can see from grounds 6A, 6B and 8A, Mr Azima also applied for permission to adduce fresh evidence. So far as grounds 6A and 6B were concerned, this was fresh evidence as to the hacking, and ground 8A was concerned with evidence from one of the purchasers of the hotel, and Mr Naibi, to the effect that Mr Azima had introduced him and the other purchasers to the transaction. So those were the grounds of appeal. Now, those grounds of appeal do not indicate that Mr Azima would either be seeking to set aside the Lenin judgment for fraud or ask for it to be remitted either in whole or in part. But as I shall show the court in a moment, those arguments were expressly canvassed by Mr Azima's counsel, Mr Tim Lord, KC, in the course of argument before the court, and Mr Tomlinson, KC, who appeared for RAKIA, did not object to the appeal being expanded to address those points, and the Court of Appeal therefore ruled on those issues in its judgment. And in the event, as the court probably knows, the Court of Appeal took the grounds in a slightly different order. They asked to be addressed first on ground 5, i.e. the consequences, if it was shown that RAKIA was responsible for the hacking, before hearing argument on the other matters. And if we can look briefly at how the argument was put before the Court of Appeal, because it's relevant to understand the Court of Appeal's judgment, and secondly, to demonstrate that Mr Azima is in fact running the same case now that he previously ran before the Court of Appeal. And if I can give your lordships the headline points before we have a quick look at the transcripts. It was Mr Azima's case last time before the Court of Appeal that RAKIA had procured the Lenin judgment by fraud. In particular, Mr Azima's counsel, Mr Lord KC, submitted there had been massive and pervasive dishonesty about the hacking involving all of RAKIA's witnesses. Mr Azima's counsel said that the truth was that RAKIA had procured the hacking of Mr Azima, that Mr Page and Mr Halibi, and probably others, had conspired to give false evidence about how they came across the hacked material, that Mr Buchanan and Mr Gerrard had between them created a false paper trail to add credence to the Page Halabi account, and that the ruler had also given false evidence. And although Mr Azima's counsel, Mr Lord KC, accepted that by his appeal Mr Azima was not seeking to challenge the judge's findings of fraud, Mr Lord argued that the pervasive dishonesty of RAKIA's witnesses had contaminated the whole trial and called into question RAKIA's credibility more generally, including on issues of reliance with regard to the misrepresentation claims, and with regard to the conspiracy claim, where it was said that Mr Naibi's evidence was that Mr Azima had introduced buyers to the hotel. And Mr Lord submitted that Mr Azima had options. He could either bring fresh proceedings to set aside the Lenin judgment for fraud, or he could apply to the Court of Appeal to have the case remitted for a retrial. And Mr Lord argued strenuously for the latter, saying it would further the overriding objective for the case to be remitted rather than leaving Mr Azima to start a fresh action to set the Lenin judgment aside. Now, we have the relevant extracts from the transcripts of the hearing before the Court of Appeal behind tabs 8, 9 and 10 in the supplemental bundle. And if we turn behind tab 8 to the submissions on day 1, we can see page 1 in the manuscript, top left-hand corner, that the appeal opened with Lord Justice Lewison explaining that the Court of Appeal would like to hear from the parties first in relation to ground 5. That's the question of the consequences if hacking was established. Should it follow that the claims were struck out or the evidence excluded? And on page 4 in the manuscript on this page, bottom right-hand corner, we can see that Lord Justice Lewison intervened early on to make the point that, putting to one side privileged material, all of the documents that were hacked would have been disclosable. And Mr. Lord accepted they would have been, although he stressed that it included some privileged material which would not have been. In fact, there were very few documents that were privileged. There were some, but they were very few in number. And we can see that Mr. Lord then went on to make the point we see him making repeatedly at line 15, page 4, that a massive deception had been practiced on the court by RAKIA. And just pausing there, it's worth noting that Mr. Lord had to pitch Mr. Azima's case that high, last time he was before the Court of Appeal, in order to bring the case within the test formulated by Lord Clerk in Summers and Fairclough, which was the power to strike out for an abusive process. And Lord Clerk in that case had said that if a massive deception has been practiced on the court, then exceptionally you might be able to strike out in those circumstances. And that's why one sees Mr. Lord pitching it that high. And over the page, at page 6, line 6, Mr. Lord says this: there are two related wrongs by RAKIA here. First, the hacking, and RAKIA's deliberate deception of the court, denying its role in the hacking, in which it continues to persist, and the presentation of a false case as to how it obtained the material. And then if we turn on to page 5 in the supplemental bundle, manuscript 29, line 21. Just bring that up. Page 5, I'm grateful. Yeah, page 29 at the top. If we look at line 21, we can see once again how high Mr. Lord was putting his client's case. He said, it's not just a question of RAKIA's witnesses lying, but RAKIA's pleaded case as to how it came by the data, the judge found to be false. But if we are right, and RAKIA is responsible for the hacking, your Lordship will see in our submission just the extent of the deception that has been practiced on the court. All of RAKIA's witnesses denied hacking or knowledge of it, and they gave oral evidence to that effect. And then dropping down to line 8. So in our respectful submission, this would be a deception of the court on a massive scale if it turns out that RAKIA is in fact responsible for the hacking. And Mr. Lord then turned to consider the implication for RAKIA's witnesses if they were found to have lied about the hacking. And we can see that if we turn to page 6 in the supplemental bundle, manuscript page 39, line 8. Grateful. Mr. Lord says this at line 8 on page 39. The second connection is this, that the deception of the court by RAKIA in relation to its liability for the hacking, we say casts the longest of shadows over the rest of RAKIA's evidence to the court. A party practicing such a deception on the court, this is page 39, line 8, my lord. A party practicing such a deception on the court is likely to forfeit any credibility, and it should be treated as a court treated Mr. Page at paragraph 64 of the judgment, namely to reject the evidence entirely unless it is independently corroborated. If one looks at the judgment of the learned deputy judge, we submit that it's most unlikely that a court would have come to the same findings if RAKIA's evidence was, as it should be, we say, set at naught on the basis of this massive deception that it sought to practice on the court. And in fact, as we shall see subsequently, first, the Court of Appeal did not accept that argument, that just because a witness has lied on one matter, it followed that he has lied on other matters. And second, the key issue of RAKIA's reliance was independently corroborated by contemporaneous documents. So I'll come back to that. Dropping down to manuscript page 40.
Just before you do,
yes.
Sorry, no, you're on page 40, yes.
Yes, at line 8, Mr. Lord concluded by saying this: so we do say that there are likely to be material aspects of the judgment that could have been differently decided if the court knew that RAKIA was trying actively to deceive it in the way that, on this hypothesis, it was. It's very hard to read that judgment and to think that the court could have come to the same views about all manner of things if it had understood that RAKIA was guilty of hacking. That was likely to have, we say, a transformational effect on this case. So we say that the connection between the hacked material and the case advanced means that the whole claim is contaminated to pick up the language of Lord Clark in that postscript. That's the postscript to the Summers and Fairclough case. And then at manuscript page 41, over the page 7 of the bundle, at line 6, Mr. Lord continued, the hacking question was so important in the trial that to come to the court and advance a false case on that, in our submission, really goes to the heart of the process and fundamentally disrupts and prejudices and dislocates it. At which point Lord Justice Mayles intervened, saying, one way of looking at it might be that however egregious the hacking was, its deployment in the trial, on one view at any rate, was not to frustrate a fair trial, but to achieve one. Wouldn't that be one way of looking at it, i.e. to expose Mr. Azima's fraud, as the judge found he had committed? So Lord Justice Mayles was clearly not entirely persuaded by Mr. Lord's arguments on the merits, and we will come back to that. And if we move forward to page 13 in the supplemental bundle, page 96 in the manuscript, page 13, page 96 in the manuscript, at line 14, we can see Mr. Lord expressly recognising that one of Mr. Azima's options would be to apply to set aside the Lenin judgment for fraud. Mr. Lord said this, page 96, line 14. We therefore say, and it will be our submission, that there is plenty of material in this case now available to Mr. Azima, quite properly, to bring proceedings to set aside this judgment of Deputy Judge Lenin on the basis that it has been procured by fraud. Particularly in the light of the further evidence that has become available, those would be, in our submission, very strong proceedings. We have therefore properly sought to bring forward that material through, effectively, the Ladd and Marshall mechanism to have it taken account of within these proceedings. And Mr. Lord clarified that submission a little later on at page 103, line 25. It's page 15, using the tab pagination. Very full. Page 103, line 25. Mr. Lord says, as my lady, Lady Justice Asplin, explains in the Dale and Bangor case, there are two options for a litigant in the position of Mr. Azima. He can either, and these aren't alternatives, he can either start fresh proceedings or he can seek to have matters reopened on the appeal. That's what we are doing. And Mr. Lord then moved on to make submissions about the extent to which RAKIA's witnesses had been involved in covering up any hacking. At page 150 in the manuscript, which we have page 19 behind tab 8. Very full. It's page 150 in the manuscript, line 9. Mr. Lord says this: our case in closing was that the hacking was procured by Mr. Page on the instructions of the ruler, and that Mr. Page and Mr. Halabi covered this up. We then also make the submission that the evidence indicated that others were probably also involved, but this was not essential to Mr. Azima's case in proving RAKIA's responsibility if it had shown that Mr. Page had organised the hacking on the ruler's instructions. And then at page 151 in the manuscript at line 9, Mr. Lord went on, RAKIA say that the judge did not make any adverse findings against Mr. Gerrard, Mr. Buchannan or the ruler. That's incorrect. The judge found that Mr. Buchannan, Mr. Gerrard and the ruler had minimised Mr. Page's role and their awareness of him and the project update. That was the one Project Beach report that had been disclosed, my lords. And he gives some references. The judge found that Mr. Buchanan had given a false explanation for his failure to mention Mr. Page's role in drafting the project update. And he gives more references. The judge also rejected the ruler's evidence as to his reasons for ordering Mr. Azima to be targeted and gone after, and the judge found that it was in fact prompted by the update. So Mr. Lord was clearly impugning the credit not just of Mr. Page and Mr. Halabi, but also other RAKIA witnesses, including Mr. Buchanan, Mr. Gerrard, and the ruler. And Mr. Lord then developed that submission further at the start of the second day of the appeal, which we have behind tab 9. You can pick it up at page 1. It's page 10 in the manuscript, where we can see that Mr. Lord referred to an email from Mr. Gerrard to Mr. Del Rosso about the discovery of the hacked data on the torrents, and suggested that what Mr. Gerrard had recorded was false. And Lord Justice Lewison intervenes on page 10 at line 21 to say, just to pause a moment, you're saying, are you, that this email exchange at tab 13 is what? Fabricated, because the information had already been given a week earlier. And Mr. Lord replied that it could not be accurate and therefore called for an explanation from Mr. Gerrard. And he then goes on to refer to an email from Mr. Buchanan, which he also suggests was fabricated. Mr. Lord said this on manuscript page 11 at line 11, your lordship will see that Mr. Buchanan is purporting to break the news of the discovery of these links to Mr. Azima's data on the internet in this email to Messrs. Frank, Anjani and Gerrard. That's on 16th August. We know from the dates we've already seen that it didn't happen around 15th or 16th. It happened more than several days earlier. So the question really then was, what was this email? Why did Mr. Buchanan send this email? And he then refers to Deputy Judge Lenin's judgment and quotes from this. We can see this on manuscript page 12, where the judge said, the email reads as though Mr. Buchanan was breaking the news regarding the hacked material, as Mr. Buchanan accepted in cross-examination, even though on RAKIA's case, Mr. Buchanan had been informed of the hacked material by Mr. Page over a week before, on 8th or 9th of August 2016. So Mr. Lord was saying and submitting that the conspiracy to cover up the hacking went wider than just Mr. Page and Mr. Halabi. He was suggesting that Mr. Gerrard and Mr. Buchanan were also involved and were laying a false paper trail, breaking the news about how they had discovered the email on the information on the internet. And one sees that submission over the page, manuscript page 13, line 18, where Mr. Lord says this, Mr. Azima submitted that a false paper trail had been laid in the sense of an attempt to lay an email trail as to the alleged discovery to serve as some sort of alibi as to timing and manner of discovery, but that was not a true version of things.
Sorry, where are we?
Page 13, my lord, in the transcript, line 18, one sees Mr. Azima submitted that a false paper trail had been laid in the sense of an attempt to lay an email trail as to the alleged discovery to serve as some sort of alibi as to timing and manner of discovery, but that was not a true version of things, and that what was really happening was this was part of a cover-up of the true way in which RAKIA had procured access to Mr. Azima's data. So we say the Court of Appeal could not have been under any illusion that it was Mr. Azima's case that all of RAKIA's witnesses had lied about and tried to cover up the hacking, not just Mr. Page and Mr. Halabi, but Mr. Gerrard and Mr. Buchanan, who were said to have created a false paper trail, and the ruler's integrity was also clearly being challenged. And one sees that again at page 5 behind tab 9 in the bundle, manuscript page 41, where Mr. Lord is suggesting that another RAKIA witness, Mr. Del Rosso, was instructed by Mr. Gerrard to arrange for the hacked material to be downloaded by a company called NTI in America. And he submitted that this was just going through the motions.
Sorry, I haven't found this.
It's page 41 in the manuscript.
Yes.
Yeah.
And it's line 16, where he says, the very thing that NTI were asked to do by Mr. Del Rosso in relation to the innocent discovery was something that was already being done for RAKIA by this Indian Operation Cyberroot at the time in 2016. So he's saying that, in fact, they'd got the hack material earlier through Cyberroot, and they were then just going through the motions instructing NTI to download the evidence to make it look as though that was how they'd come across it. We say that when one puts it all together, the case is overwhelming that RAKIA had procured the hacking. There has been a grotesque miscarriage of justice here, unless this is intercepted. That's why we earnestly ask for the matter to be remitted so that the matter can be fairly resolved. And Mr. Lord then went on to make submissions to the Court of Appeal about the procedural mechanisms available to Mr. Azima to try to correct the miscarriage of justice. And we can see that if we turn to page 12 in the bundle and look at manuscript page 69, line 8, where Mr. Lord makes his submission about what should happen. Manuscript page 69, line 8. Mr. Lord says this: given the nature of the further evidence that Mr. Azima has now managed to find, he would be entitled to bring fresh proceedings in the High Court to set the judgment of Deputy Judge Lenin, to set aside the judgment of Deputy Judge Lenin, on the basis that RAKIA had procured that judgment by fraud. And there could be no answer really from RAKIA that it was an abuse, so there could be fresh proceedings to set aside the judgment, and not just the hacking judgment, but the judgment, i.e. the judgment in RAKIA's favour on its claims that it had been defrauded by Mr. Azima, because that would be the order that would be set aside. We say, and it really is an answer to the loud and martial response by RAKIA, in our respectful submission, it's a complete answer really to this point, is that what Mr. Azima has done, quite properly we say, and as the court might well expect him to do, is to bring this further evidence before this court on this appeal, so that this court is able to consider whether the evidence should be considered by way of a remission to the court within the existing proceedings that are on appeal, rather than having the inefficient and slow process of starting fresh process. And that far from Mr. Azima being liable to be criticised for what he's done, as RAKIA do, he's actually done the right thing. Mr. Azima had options here. He could have simply issued fresh proceedings, but quite properly, given this pending appeal, he has deployed this further material on this appeal. And then Mr. Lord went on to make submissions on the law and the process to be followed. On page 71 in the manuscript, at line 11, he said this: looking at the question of the proper process, as your lordship observed to me a few moments ago, the old view was evidence that a judgment was obtained by fraud should found an application to set aside the judgment instead of being raised on appeal. That rule was revised in 2010 in the case of Noble and Owens, as your lordship knows. And Mr. Lord then refers to the White Book, and on page 73 of the manuscript at line 4, he refers and makes submissions on the decision of Lady Justice Asplin in Dale and Bangor, and we'll see in due course the relief that Mr. Lord asks for in light of the fresh evidence of the hacking. But before turning to that, I just want to look at an important exchange which takes place between Mr. Lord and the Court of Appeal towards the end of day 2. It's tab 9, page 16, page 145 in the manuscript. Tab 9, page 16, page 145 in the manuscript. And we can pick it up at line 21, where Lord Justice Mayles intervened to say this: just to be clear, Mr. Lord, in relation to ground 7, that's the ground challenging reliance, the heavy lift claim you are challenging the findings of reliance, for which purpose you bring to bear the submissions you've made in relation to the hacking points. So he's saying there's a crossover between the hacking and the issue of reliance. But you're not challenging the finding of fraud on the part of Mr. Azima. That's right, isn't it? And Mr. Lord replies, not save by way of, if this matter is remitted because of the fraud on the hacking, we say it would be appropriate for a trial judge to review the whole case. And Lord Justice Mayles says, well, you haven't said that in your grounds of appeal. And Mr. Lord replies, well, we've asked for a retrial of the matter, and we've challenged the whole order. And then at page 147 in the manuscript, a few moments later, line 8, Lord Justice Lewison intervened as well. He said, that may be, Mr. Lord, but which of your grounds of appeal challenges the fraud finding? I'm looking at your amended grounds of appeal, and I can't at the moment see that any of them challenge that finding. Mr. Lord says, no, my lord, that's true, but we do make the global challenge under obviously ground 5, so the abuse and the admissibility go to Lord Justice Lewison. Ground 5 is, as I understand it, even if Mr. Azima was guilty of fraudulent misconduct that the judge found him to be guilty of, nevertheless, because RAKIA had orchestrated the hacking, the whole claim ought to be struck out. That ground is not saying, and what's more, the judge was wrong to find fraud on the part of Mr. Azima, and it's certainly not addressed in your skeleton argument as far as I can see. So I think my lord's point is a correct one. You're not challenging the findings of fraud against Mr. Azima, to which Mr. Lord replies, well, I think that's correct. That's correct. In relation to the ground 7 appeal, though, we are challenging reliance, and we are saying that if in fact RAKIA gave false evidence about the hacking in the way we say it has, it's very hard to see how any of its oral evidence will be accepted, including that of the ruler and the evidence of other witnesses like Mr. Buchannan. It's very hard to see how any of that would have been accepted, and we say that therefore would follow that reliance not having been made out by RAKIA, there will be no establishment by it of its misrepresentation claims, either the heavy lift investment or the good faith one. That's our first complaint. To which Lord Justice Lewison replies, but if the judge had rejected and found that RAKIA had been lying about the hacking, surely he would have given himself a Lucas direction to say that just because they're lying about that doesn't mean that they're lying about everything. So the point you make, that if they've been disbelieved on the hacking, it would follow that they would be disbelieved about the reliance, is a non sequitur, isn't it? And that's a reference to the case of R. and Lucas, 1981, Queen's Bench, decision of the House of Lords.
So lies direction is given in a criminal trial.
Correct, my lord. And they sometimes are made in civil proceedings as well. Mr. Lord, however, went on to say that the case should nonetheless be remitted, and he developed that submission further on day 3, which we have behind tab 10 in the supplemental bundle.
Yeah.
And we can pick it up on page 3 of the bundle, page 24 in the manuscript, at line 9, where Mr. Lord says this. There are obviously 2 options in accordance with Dale and Bangor. First is fresh proceedings by Mr. Azima.
Sorry, I've lost you again. Where are you?
It's page 24 in the manuscript at line
That
9.
accounts why I wasn't keeping up. Yep, thank you very much.
There are obviously 2 options in accordance with Dale and Bangor. First is fresh proceedings by Mr. Azima, which he would be perfectly entitled to pursue in view of that material. That's a reference to the fresh evidence of hacking. Alternatively, or rather a second option, it may not be an alternative for him, is to remit within the existing proceedings. We respectfully submit the overriding objective comes down firmly in favour of remitting in the existing proceedings in terms of dealing with the case justly and saving expense. When looking at the options between fresh proceedings and existing proceedings, the new evidence goes to issues in the case, so not just collateral matters of credibility, although it does show that judgment was procured by fraud, but that's not its only reach. And Lord Justice Lewison then intervened to ask if the matter were remitted, whether it would have to be remitted to a different judge. And if we turn over the page to manuscript page 25 at line 2, we can see Mr. Lord replied, "My Lord, we respectfully submit that rather like the example of Bank St. Petersburg in the Court of Appeal, in which my Lord Justice Mells was on the bench, it may be more appropriate, we submit, for it to go back to a different judge. That's what happened in Bank St. Petersburg." And then dropping down to manuscript page 26, line 10, we can see that Lady Justice Aspelin intervened to say, "On that basis, Mr. Lord, I'm just thinking about the overriding objective. Why do you therefore say it'd be more just, save time, be more cost effective to be remitted rather than to commence a fresh action?" And Mr. Lord said, "Yes, can I make that submission? My lady, in the Bank of St. Petersburg, what the Court of Appeal did was to remit the matter back to a different Chancery judge, but giving various directions as to how the matter should be re-evaluated. They didn't, I don't think the Court of Appeal fettered what the remitting judge, what he or she could do in terms of further evidential steps, but they did give various directions and guidance designed to allow that judge to confine that further investigation and fact-finding, including taking into account the existing findings that had been made by the original judge, Mr. Justice Hildyard. So there was a sort of structured remission, albeit to a different judge, designed to try and retain a large amount of the architecture from the original fact-finding process, if I can put it that way. And that's important, my lords, because when we come to look, as we will in a moment, at the Court of Appeal's judgment and what it ordered, we will see that it went down exactly this route. It orders remission to a different judge, Mr. Justice Michael Green, but it makes orders about the extent to which a large amount of the architecture from the original fact-finding process was to be preserved.
Yeah.
And in particular, it says that Deputy Judge Lennon's findings on RAKIA's claims and the finding that Mr. Azima was a fraudster must stand and could not be challenged on remission. And we'll come back to that in a moment. And Mr. Lord then went on to make lengthy submissions, which start on page 27 at line 19 and go down to page 41, line 16, as to why it would be more appropriate for the Court of Appeal to order remission rather than to leave it to Mr. Azima to commence fresh proceedings to set aside the Deputy Judge's judgment for fraud. And Mr. Lord made a number of points as to why fresh proceedings would not be appropriate, touching on jurisdiction, service of documents, state immunity points that might be taken against him, costs, delay, and questions of fairness to Mr. Azima. And we can pass straight to his concluding submission at page 41 of the manuscript, which we have at page 8 in the bundle, page 41 in the manuscript, line 12, where Mr. Lord submits, we say for all those reasons point overwhelmingly in favour of allowing further evidence in the existing proceedings and then remitting them back to the Chancery Division for further consideration. I've made my submissions on how that remission might be done. Further down the page, at page 42 of the manuscript, line 14, Mr. Lord said that if the Court of Appeal was going to remit, it should hold over the question of ground 5 relief, i.e. whether RAKIA's claim should be struck out.
Sorry, where are we on?
Page 42 in the manuscript, line 14.
Line 14.
The submission starting Mr. Azima shouldn't, in fairness.
Yeah.
What he's saying is that if the Court of Appeal does go down the remission route, it shouldn't determine ground 5, the strikeout or non-admissibility. It shouldn't decide that now, but should hold that over until the end of the trial. Mr. Azima shouldn't, in fairness, be denied his ground 5 relief until the hacking has been finally resolved, because we say that on what was before Deputy Judge Lenin and what is now before this court show overwhelmingly, we say, that RAKIA did the hacking. So to pick up the language in the ladder marshal cases, there is a risk of a gross miscarriage of justice. If that's right, and we say that if Mr. Ray is right, it was Mr. Ray's evidence on the fresh evidence on the hacking, it's the end of the matter. If that's right, how can this court, in fairness, allow RAKIA to have its judgment on its claims when there are all those points that need to be taken into account by the English court that would go to defend, defeat, strike out RAKIA's claims? It would be wrong in principle to say to RAKIA, you have your claims now, and leave Mr. Azima to his fresh proceedings. As we will see, the Court of Appeal disagrees with Mr. Lord, and it's precisely what the Court of Appeal does order. It determines the ground 5 issue first, and having resolved that issue against Mr. Azima, it ordered a structured remission of the hacking counterclaim to a new judge, making it clear that RAKIA's claims must stand, whatever the outcome of the remitted proceedings. And for his part, Mr. Tomlinson QC opened his submissions by reminding the Court of Appeal of the findings of fraud made by Deputy Judge Lenin and the fact that those primary findings were not challenged on the appeal. We can see this page 44 of the manuscript, line 8, where we have Mr. Tomlinson's submissions. He says, my lord, in this appeal, a man who has been found by the judge and does not appeal that finding to have committed multiple frauds, having lied persistently to RAKIA, but also to the court, to have created false documents to support those lies, now comes to this court and seeks to evade the consequences of his own unlawful and dishonest conduct by saying that the court was misled about how the evidence of that dishonesty was obtained. Mr. Lord obviously has some difficulty in acknowledging that his client has been found to have committed these frauds, and when taxed with it yesterday, was in the end obliged to accept that those findings are not the subject of any appeal, and his only challenge to them is on the basis of the ground 5 abuse of process point. That was the passage we looked at a short while ago. And Mr. Tomlinson then turned to address the 9 grounds of appeal. We can pick it up for present purposes at page 9 of the bundle, behind tab 10, at page 96 in the manuscript, where Mr. Tomlinson was developing his submissions about whether the Court of Appeal should order the case to be remitted or whether it should leave Mr. Azima to commence a fresh action. And at line 8, Mr. Tomlinson said this, I begin by saying something about the law. It appears that this is largely uncontroversial and fortuitously has been helpfully summarised by my lady in the Dale and Bangor case decided, I was going to say last week, but very recently. The effect of the authorities we submit is as follows, that where a party raises an allegation that a judgment has been obtained by fraud in the course of an appeal, because of course they could just raise the allegation in a fresh action and it doesn't involve the appeal court at all, but if they raise the allegation in the course of the appeal, there are 3 possibilities. First of all, the fraud is admitted or the evidence is incontrovertible. Then the court will allow the appeal and order a retrial. That is Dale and Bangor, and he refers to paragraph 41 of the judgment. Then going over the page at line 3 in manuscript, page 97, One also finds that discussed in Noble and Owens itself. So that's the first option, which of course is plainly not the case here. The second option is if the new evidence is capable of showing that the judge was misled, then the court must decide whether or not the issue should be remitted in accordance with the Noble and Owens lines of authorities. That's a two-stage test, as my lady sets out in paragraphs 42 and 43 of Dale and Bangor. First of all, there's the capability threshold, and if that's satisfied, then there's a discretion to be exercised in accordance with the overriding objective, effectively making direction on 5220 subparagraph 2b for that issue to be dealt with by the lower court. The third option, it's not incontrovertible, so it's not 1. As a matter of discretion, it's not remitted, so it's not 2. The third option is the appeal is dismissed, and the party is, as it were, put to their choice as to whether to bring a fresh action to set the judgment aside. And then if we drop down to page 98 in the manuscript at line 8, Mr. Tomlinson makes the point that none of this has in fact been pleaded or set out by Mr. Lord in his grounds of appeal. He said, strictly speaking, none of that applies here because, strictly speaking, on the case that's advanced by Mr. Lord in this court, he's not asking for either 1 or 2. He's actually asking for the new evidence to be taken into account and used as a basis for a determination by this court that that was hacking. So, in other words, Mr. Tomlinson was alive to the pleading point and the disconnect between Mr. Azima's grounds of appeal and the relief that he was now seeking. But he made it clear he wasn't going to take any technical objection to that. He says this at the top of page 99. So strictly speaking, all Mr. Azima is asking for is for the court not to set the judgment aside on the grounds of fraud and not to invoke any of this jurisprudence at all, but to use the new evidence as the basis for a finding by this court of hacking. Now, I don't want to waste time and be unrealistic. It's obvious that's not really what Mr. Lord is asking for. Mr. Lord isn't really, that may be one of his submissions, but he's obviously also saying, as was being discussed this morning, for a Noble and Owens direction. That's my understanding of the way he puts his case. I'm not going to waste time by saying, well, he should have said so in his grounds or his notice of appeal. Perhaps he should, but we are where we are. So the question for this court is whether either my second or third alternative should be taken. In other words, whether this should be a Noble and Owens direction or whether the appeal should be dismissed and Mr. Azima left to his new action. To avoid leaving the court in suspense, let me go immediately to the end of the story and say this. We say the court should dismiss the appeal, require Mr. Azima to bring a fresh action. And he then develops his submissions as to why that would be more appropriate, the more appropriate course than Mr. Lord's suggestion of a structured remission to a different judge, essentially saying he was prepared to give undertakings that RAKIA's solicitors would accept service and would not take state immunity points, and that given the need for fresh pleadings, fresh disclosure, and fresh witness statements, that was effectively a fresh action. And on the ground 7 challenge, reliance, Mr. Tomlinson pointed out that the contemporaneous documents in fact were there to support RAKIA's case on reliance. We can see that if we turn on to page 13 in the bundle, manuscript page 111 at the top of the page, where we can see that Mr. Tomlinson referred to a letter from Mr. Buchannan, RAKIA's chief executive officer.
Sorry, page?
Page 13 in the bundle, manuscript page 111.
Yeah.
And at line 11, having referred to a letter from Mr. Buchanan to the ruler, Mr. Tomlinson says this. So he's written to the ruler on RAK development note paper, him and Mr. Bustani, concerning the settlement agreement with Farhad Azima. The letter is at pages 40 and 41. The letter expressly highlights the provision that Mr. Azima has represented is acting in good faith, which they say is the key clause in the agreement, and then recommends, this is the final paragraph on page 41, Your Highness, we believe the agreement achieves the objectives we've been seeking, and we recommend that you authorise James Buchanan to sign under the RAKIA power of attorney to which he has been granted wide powers. And Mr. Tomlinson says there was no dispute that that letter was sent, and he then turns to the law and the proposition which found favour with the deputy judge, and as we will see, found favour with the Court of Appeal, that if a misrep is made to an agent who relies on it to make a recommendation to his principal, does not pass on the misrep, the principal is nonetheless entitled to relief. And at line 19 on page 112, Mr. Tomlinson says, the recommendation letter itself is a strong basis for a factual inference that the ruler relied on the representation. relied on the recommendation and therefore on the representation. It's not suggested that the letter was a sham or part of a false paper trail. As we note in our skeleton, it would be surprising if the ruler, having sought Mr. Buchanan's recommendations and decided to follow it, doesn't place any reliance upon it. And then over the page, at page 14 in the bundle, page 113 in the manuscript, line 21, Mr. Tomlinson makes this further point on reliance. It is also, of course, significant that the settlement sum is the sum that was 2.6 million, is the sum which Mr. Azima represented falsely that had been contributed by Heavy Lift to the training academy. So just pausing there, in answer to Mr. Lord's generic submission that if it could be shown that RAKIA's witnesses had lied about the hacking, then a court should set all of the witness evidence at naught, including the evidence on the issue of reliance, unless it was supported by contemporaneous documents. There were, in fact, two answers. The first was Lord Justice Lewison's point that, in fact, in accordance with a Lucas direction, it did not follow that just because RAKIA's witnesses had lied about the hacking, that they had also lied about other issues such as reliance. And the second was Mr. Tomlinson's point that, in fact, there was powerful contemporaneous evidence in the form of the recommendation letter and the settlement agreement itself, which showed that RAKIA had relied on the Heavy Lift misrepresentation and the good faith misrepresentation. And as for the argument that there was fresh evidence in the form of the witness statement from Mr. Naibi, one of the purchasers of the hotel, which corroborated Mr. Azima's claim that he had introduced the purchasers to the transaction, Mr. Tomlinson submitted to the Court of Appeal, and as we will see, the Court of Appeal agreed with him, that this would not have had any material impact on the judge's finding that the referral agreement was a sham. And one sees that at page 15 in the bundle, the submission at page 126 of the manuscript, line 1, page 15 in the bundle, page 126 in the manuscript, line 1, where Mr. Tomlinson is talking about Mr. Azima's application to adduce Mr. Naibi's witness statement as fresh evidence. Mr. Tomlinson said, "So we say the evidence doesn't satisfy that requirement of Latin Marshall either, and it wouldn't in any event have an important influence on the trial, because the judge's conclusion, as he makes clear at paragraph 181 of his judgment, his conclusion that the referral agreement was a sham was based on a wide variety of factors, nothing to do with the finding that Mr. Azima had not introduced the potential buyers. Perhaps it's just worth taking that up. 181 is at," and he gives the reference to the judgment, and we've looked at that paragraph. At subparagraph 1, he describes the agreement as implausibly generous. He regards Mr. Azima's suggestion that he agreed to a 50% cut in his commission, even though he had performed his side of the bargain, as wholly implausible. He then goes on to say he didn't effect an introduction, which is the point about Mr. Naibi's evidence. He then refers in the succeeding paragraphs to the suspicious circumstances of the drafting of the referral agreement and its backdating and the use of Mr. Al-Sadek's private email. So the judge regarded those factors as powerful factors against the case that Mr. Azima was advancing on this point. And as we will see in a moment, the Court of Appeal agreed with Mr. Tomlinson on that submission and found that even if the evidence showed that Mr. Azima had introduced the buyers to the hotel transaction, that would not have had a material influence on the judge's decision that the referral agreement was a sham. And that becomes relevant in this appeal because one of Mr. Azima's points is that some of the Project Beach reports, he says, suggest he had effected the introduction. But our point in riposte to that is the Court of Appeal has already considered this point, albeit in a slightly different context, Mr. Naibi's evidence, and they said even if he did effect the introduction, it would not matter. It would not have a material impact on the Deputy Judge's judgment. So the point has already been argued and resolved against Mr. Azima.
And that's because the basis upon which he asserted an entitlement to remuneration for the introduction was the sham referral
agreement. And there were a whole host of other reasons why Deputy Judge Lenin found the referral agreement to be a sham, which we've looked at, which were independent to the point about the introduction. So that was all I wanted to do by way of showing the Court of Appeal the transcripts and how the argument proceeded. And then if we can turn to the Court of Appeal's judgment, which we have at tab 11 in the supplemental bundle. And the court starts, it's page 2 behind tab 11, by giving an introduction to the factual and procedural background of the case at paragraphs 1 to 5, before turning to the shape of the appeal at paragraphs 6 and 7 on the 3rd page. And the grounds of the appeal and the relief sought, as developed in argument, were then summarised by the Court of Appeal very helpfully in paragraph 7, where the Court of Appeal said this: on this appeal, Mr Azima raises a number of grounds. The main focus of those grounds, grounds 1 to 4, is an attack on the judge's findings in relation to the responsibility for the hacking. There is barely any quarrel with the judge's substantive findings in relation to the underlying factual basis of RAKIA's underlying claims. Just pausing there, that reflects Mr Lord's concession, which the Court of Appeal had wrung out of him, that he was not seeking to appeal the Deputy Judge's findings of fraud against Mr Azima, the forging of documents, passing them off as genuine, paying bribes, etc. Then the Court of Appeal went on. Ground 5 asserts that if the judge had found that RAKIA was responsible for the hacking, he ought to have struck out the claim as an abuse of process. In consequence, ground 6 asserts the counterclaim was wrongly dismissed. Ground 7 to 9, as originally formulated, make further criticisms of the judge's findings of fact in relation to the underlying claims. Then at paragraph 8, the Court of Appeal refers to Mr Azima's applications for fresh evidence, and based on that, the further relief that he sought from the Court of Appeal in the course of argument, the court said this: in support of his appeal, Mr Azima also applies for permission to adduce fresh evidence. These applications are the subject of grounds 6A, 6B, and 8A. This new evidence, when taken with the evidence before the judge, is said to be sufficient to prove that RAKIA obtained Mr Azima's personal data by hacking his email accounts, and that the information which has been obtained by unlawful means was used as a basis for RAKIA's claims against him. This court should make that finding a fact. The consequence of that, once more, is that the action should be struck out as an abuse of process. And then this: in the alternative, it is argued that the issue whether RAKIA was responsible for the hacking should be remitted for retrial. And since the judge's decision that Mr Azima had not proved his hacking allegation was fundamental to at least some of the conclusions on RAKIA's substantive claims, they too should be remitted for a retrial. So, just pausing there, the Court of Appeal was under no illusions as to what Mr Azima was asking for. If the Court of Appeal was not prepared to find as a fact that RAKIA was responsible for the hacking, what Mr Azima was asking for was remission, not just of the hacking counterclaim, but also remission of RAKIA's claims in the main action on the basis that those claims would be affected or could be affected by the outcome of the hacking counterclaim. But as we shall see, the Court of Appeal emphatically rejects that argument. It orders remission of the hacking counterclaim, but the hacking counterclaim only, and it makes it clear that whatever the outcome of the hacking counterclaim, the judgment on RAKIA's claims in the main action must stand and should be binding on the judge hearing the hacking counterclaim. And it says the only parts of RAKIA's claim that the judge hearing the hacking counterclaim can interfere with is the award of interest and costs. And the Court of Appeal then sets out at paragraphs 9 to 21 in more detail the factual background, the hacking of Mr Azima's emails, and Mr Azima's case on the hacking. And at paragraphs 22 to 38, the Court of Appeal, which we have page 8 in the bundle, the Court of Appeal then summarises the judge's findings on the hacking counterclaim. And then if we turn on to page 14 in the bundle, paragraph 39, the Court of Appeal summarised the approach that it would take on the appeal, under heading our approach to the appeal. And it says it would take the grounds of appeal in a different order to that in which they were advanced. It would first consider whether, if RAKIA was responsible for the hacking, whether the evidence should be excluded or its claims struck out. It said that second, it would consider the judge's conclusions on the fraudulent misrep claims and the conspiracy claim, including the application to admit fresh evidence on the conspiracy claim, that's Mr. Naebi's evidence, and it said that third, it would consider the judge's conclusions on the hacking counterclaim together with the application to admit fresh evidence in relation to that. And the Court of Appeal therefore turns to address ground 5. And under the heading, should the evidence have been excluded, at paragraph 40, the Court of Appeal sets out the assumptions it was prepared to make in Mr. Azima's favour for the purposes of determining ground 5. The Court of Appeal says this at paragraph 40. Before considering the grounds attacking the judge's rejection of Mr. Azima's hacking claim, it is convenient to consider what the consequences would be if that allegation were to be established. We will assume, for present purposes, A, that RAKIA's case would have failed, but for the existence of the documents obtained as a result of the unlawful hacking of Mr. Azima's computer. B, that RAKIA was responsible for that unlawful hacking. And C, that at least some of RAKIA's witnesses gave dishonest evidence about how RAKIA came into possession of the hacked material. Now, just pausing there, we've seen how high Mr. Lord KC put Mr. Azima's case on appeal. He had suggested that all of RAKIA's witnesses had lied about their knowledge of the hacking and had sought to cover it up. He had expressly not limited his case to lies being told by Mr. Page and Mr. Halabi. On the contrary, he had submitted that Mr. Page undertook the hacking on the part of the ruler. He had submitted that Mr. Page and Mr. Halabi had conspired to cover that up. And he had submitted that other RAKIA witnesses were probably also involved, although that was not essential to Mr. Azima's case. That was the submission that we saw on day 1, page 150, lines 9 to 16. And we saw how Mr. Lord had also pointed out that the judge did in fact make adverse findings about the evidence of Mr. Gerrard, Mr. Buchanan, and Mr. Ruler, and the ruler. We saw how Mr. Lord had referred to the emails passing between Mr. Gerrard and Mr. Buchanan, which purported to break the news about the discovery of the hack material on the internet, and how he had made it clear it was Azima's case that those emails between Gerrard and Buchanan had been fabricated and were a false paper trail. And indeed, the Court of Appeal had already alluded to that part of Mr. Azima's case. If we look back at page 7 within the judgment, paragraph 21, Roman 7, the Court of Appeal had noted that it was Mr. Azima's case that contemporaneous emails which show that RAKIA innocently discovered the hack material were in fact a false paper trail created by Mr. Buchanan and Mr. Gerrard in order to conceal their involvement in the hacking. So when the Court of Appeal said, as it did at paragraph 40, that it was prepared to assume in Mr. Azima's favour that at least some of RAKIA's witnesses gave dishonest evidence about how RAKIA came into possession of the hack material, we say it meant what it said. What the Court of Appeal had in mind was Mr. Lord's submission that at the very least, Mr. Page and Halabi had conspired to cover up the hacking, but that other RAKIA witnesses were also probably involved in the cover-up, and that it was Mr. Azima's case that the ruler, Mr. Gerrard and Mr. Buchanan had also told untruths about the hacking and had been involved in the cover-up, including fabricating documents.
Well, the debate about the Lucas direction only really makes sense in the context of Buchanan and Gerrard, doesn't it?
Exactly.
Well, really Buchanan, because it's Mr. Buchanan
Evidence that was
who relied.
exactly so. Exactly so.
Because Page and Halabi don't
go to
on
reliance.
case at all.
My Lord's exactly right. And we say that's important because Mr. Azima seeks to suggest that at paragraph 40, the only witnesses the Court of Appeal had in mind who might have lied were Page and Halabi, whereas he now has evidence, he says, that shows that RAKIA's other witnesses, and in particular Mr. Gerrard and Mr. Buchanan, had also conspired to cover up the hacking. And he suggests that the case has now moved on materially since this was last before the Court of Appeal. But we say he's wrong about that, for exactly my Lord's point. And as I've shown the Court, Mr. Azima's case previously went wider than Mr. Page and Halabi. It was his case before the Court of Appeal that all of RAKIA's witnesses had lied, that there had been a massive deception of the deputy judge. It was his case last time round, it's his case now. But despite assuming in Mr. Azima's favour that at least some of the witnesses had lied to the Court of Appeal said the deputy judge's findings of fraud against Azima must stand. At paragraphs 41 to 46, the Court of Appeal then reviewed a number of cases on the discretionary power that a court has to exclude relevant admissible evidence on the basis that it has been obtained by improper means. Paragraph 47, the Court of Appeal said this, paragraph 47, page 16, there are in addition two other points to be made. First, the materials which were obtained through hacking Mr Azima's email accounts were documents as defined by CPR 31.4. Ex hypothesi, they were within his control. Accordingly, as Mr Lord QC accepted, an order for standard disclosure would have required him to disclose those documents other than documents properly covered by legal professional privilege, insofar as they either supported RAKIA's case or adversely affected his own case, CPR 31.6. It follows that those materials ought to have been available to RAKIA by the time of trial. This was the point that Mr Justice Ricks made in Dubai Aluminium Company at 1969F. Second, the materials revealed serious fraud on the part of Mr Azima, which would have been a very serious bar to the grant of equitable relief in his favour, as noted in Istil. And as just pausing there, as we've seen from the Deputy Judge's judgment, that was entirely correct. The hacked evidence showed Mr Azima and Mr Adams had conspired on numerous occasions to create and backdate documents which did not reflect the true position, which they knew did not reflect the true position, in order to deceive RAKIA. The Court of Appeal went on at paragraph 48. Accordingly, in our judgment, if Mr Azima had applied before trial an order requiring the return of the hacked materials, he would not have succeeded. There is no reason to apply a different approach after the evidence has been deployed at trial. And at paragraph 49, the Court of Appeal expressly endorsed the statement made by the Deputy Judge in his judgment. If I had found that RAKIA had hacked Mr Azima's emails, I would not necessarily have excluded the illicitly obtained evidence, as without it, RAKIA would have been unable to prove its claims, and Mr Azima would have been left with the benefit of his seriously fraudulent conduct. And at paragraph 51 and following, the Court of Appeal then turns to consider the case law on the power to strike out a claim after a trial and refers to the decision of the Supreme Court in Summers and Fairclough. And at paragraph 56 on page 18, the Court of Appeal then said this: it's important to stress that the cases about striking out after trial are cases in which the underlying substantive claim has been fraudulently brought, either because documents have been forged or perjured, evidence given, or because the quantum of the claim has been fraudulently exaggerated. No case has been brought to our attention in which a claim was struck out solely because of the manner in which the evidence was obtained, even though the underlying claim is both genuine and well-founded, let alone a case in which the unlawfully obtained evidence has demonstrated fraud on the part of the defendant. In paragraph 57, the Court of Appeal said that there was, in its judgment, an important difference between a claim which is itself fraudulent or fraudulently exaggerated on the one hand, and a claim which, although well-founded, is supported by collateral lies. And it referred to the judgments of Lord Sumption and Lord Hughes in Versalute Dredging, and the comments of my Lord Justice Newey in Howlett and Davis. And at paragraph 60, the Court of Appeal said this: to put it another way, any unlawful conduct by RAKIA in obtaining the emails was not central to its underlying claims against Mr Azima, compare Grondona and Stoffel, concerning the defence of illegality. In the present case, insofar as Mr Page and Mr Halabi told lies, they were collateral and lacked centrality in this sense because they did not go to the merits of RAKIA's underlying claims. Now, just pausing there, likewise, although the Court of Appeal do not spell this out, insofar as Mr Buchannan or Mr Gerrard told lies about the hacking and had fabricated a false paper trail breaking the news to cover it up, those lies also did not go to the merits of RAKIA's underlying claims. And although Mr Lord tried to argue that if Mr Buchanan in particular could be shown to have lied about the hacking, his evidence on other matters, such as reliance, should be set at naught, as we've seen, Lord Justice Lewison pointed out the fallacy in that reasoning in the course of argument, that in accordance with the Lucas direction, the court should bear in mind that just because a witness lies about issue A, that does not mean he's lying about issue B. People lie, as Lord Lane said in Lucas, for many reasons, such as panic or confusion, out of a desire to protect someone else, conceal disgraceful behaviour or to bolster up a just cause, with the result you cannot conclude because a witness has lied about a collateral matter, here the hacking, it follows that he or she must also have lied about a substantive matter, here the issue of reliance.
Well, that's essentially the point that's made by the Supreme Court in the Gerlin case that he quoted 57. It's the critical difference between a fraudulent claim and collateral lies to bolster what was otherwise a genuine claim.
Exactly so. And Mr Azima says that if they've lied about the hacking, they've also lied about the underlying merits, but that's exactly the Lucas fallacy. You can't connect that. What is trying to establish is a lie that goes to a collateral matter, how the evidence was obtained. There is a separate issue about whether that impacts on the underlying merits, and the Court of Appeal has resolved that issue against him. And at paragraph 62, the Court of Appeal then said, 3 other points are worthy of note. First, as we have said, the hacked material ought to have been disclosed by Mr Azima anyway. Second, to strike out RAKIA's claim would leave Mr Azima with the benefit of his fraud. That element of public policy in civil cases is at least as strong, if not stronger, than disapproval of the means by which the relevant evidence is gathered. Third, there are other ways in which the court may express its disapproval of the conduct of a party found to have procured relevant evidence by unlawful means, notably by penalties and costs, or perhaps the refusal of interest on damages awarded. And standing back, the Court of Appeal then said this at paragraph 63, in our judgment, even if the judge had found that RAKIA had been involved in the hacking of Mr Azima's email accounts, it would have been wholly disproportionate to have struck out its claim, thereby leaving Mr Azima with the benefit of his frauds. And that statement, as we will see, becomes something of a repeated refrain in the Court of Appeal's judgment and is duly reflected in its order that whatever the outcome of the hacking counterclaim, the judge's judgment on RAKIA's claims must stand, and the only elements that can be reopened are the deputy judge's decisions on costs and interests. And it's a point that is repeated 5 times subsequently, paragraphs 122, 128, 145, 146, and 148. And at paragraph 66 and following, the Court of Appeal then turned to the appeals on fact, which are grounds 1 to 4, grounds 7, 8, and 9.
Yeah.
In particular, the question of whether RAKIA had relied on the heavy lift and good faith misreps, which Azima had sought to challenge on the appeal, and the question of whether the deputy judge was right to find there had been an unlawful conspiracy in the light of the fresh evidence that Mr Azima sought to adduce from Mr Naibi, one of the purchasers, to say that Mr Azima had affected Mr Naibi's introduction to the hotel transaction. And having directed itself on the law at paragraph 71, the court turns to Mr Azima's specific challenge to the deputy judge's finding of reliance. And this argument was advanced by Mr Azima as grounds of appeal and his skeleton on the narrow basis once he's summarised at paragraph 73 on page 22, that the person who took the decision to enter into the settlement agreement was the ruler. The ruler gave no evidence that he was induced to do so by anything that Mr Buchanan had said to him, or indeed by his recommendation, and Mr Lord had therefore submitted there was an evidential gap, and the court should draw an adverse inference from RAKIA's failure to address it. And the Court of Appeal rejected that specific argument. It made the point at para 74 that whilst the absence of evidence may entitle the court to draw an adverse inference, it does not require a court to do so. At paragraph 75, the Court of Appeal also referred to the presumption of materiality, noting that once it was proved that a false statement was made, that was material in the sense it was likely to induce the contract, it was a fair inference that the statement did influence the decision maker. And further at para 77, the Court of Appeal referred to contemporaneous documents in the form of the settlement agreement itself, and noted that it contained an express statement that RAKIA was relying on Azima's representation of good faith in making the payment. And the court said it was a short step from that to a finding that there was reliance. So the Court of Appeal rejects that specific line of argument on reliance. Now, of course, as we've seen, Mr Azima had made a more general argument challenging the judge's findings on reliance, to the effect that if it could be shown that RAKIA's witnesses had lied about the hacking, then their credibility should be set at naught and their testimony rejected unless supported by contemporaneous documents. But as we've seen, the Court of Appeal had already rejected that line of reasoning in the course of argument with a Lucas direction. And as the Court of Appeal had just observed at paragraphs 57 to 61, if RAKIA's witnesses had told lies about how the hacked material was obtained, those lies were collateral and did not, in and of themselves, go to the substantive merits of RAKIA's claims. I'm conscious of the time. I was going to turn to the fresh evidence on the introduction, but maybe we should do that after the break. I'm making good progress. I'm confident I will just need an hour or so after lunch to
Okay,
an
now
hour.
we'll break till 2 o'clock then.
Right.
All right.